as long as he's in your office.
I'll have him be in my office.
I don't care. That's fine. You can be in your office as long as you're both in there. Okay?
And I'll just talk to him right now. Maybe.
Stop doing this. You hear me?
What's the back class for?
Come on up, sir. Come on up. There we go. No reason to be shy. We're all friends here.
Just keep your hands on the table. Right here in the middle. Right here. Just like face the judge. Right here. Right here. Let me go. Okay.
And
No.
25 CR 817 is called the state of Texas versus Michael Jenkins. That's you, sir. Sir, you have been indicted. You probably know this with burglary of a vehicle, which is a state jail felony. You have 2 prior convictions of burglaries of a vehicle. Something about burglaries of a vehicle that attract you. But further, you've got several. This is 3 pages long, and we're talking about several prior convictions dating back to 2008 out of Gregg County, illegal possession of a controlled substance, a second-degree felony. After that was finalized, then you committed burglary of a habitation, a second-degree felony, and were convicted here in Jefferson County in 2013. And also in 2013, you had a second burglary of a habitation conviction. And looks like after all of those prior convictions were final, you were convicted in 2017 for delivery or manufacture of a controlled substance, a second-degree felony out of Montgomery County, Texas. So it looks like what we have here is a second-degree felony in paragraphs 1 and 2. I'm sorry, the state jail felony with paragraphs 1 and 2. And then the prior convictions will enhance it to second-degree felony punishment.
That's correct.
That's correct, Judge.
Okay, so you're looking at up to 20 years in prison, sir. And you're not eligible for probation in front of a jury because of your rich criminal history. You understand? So, okay, Mr. Dusler is going to represent you. You were indigent. You have to speak.
Yes.
There we go. She has to take everything down here. Look, the court reporter. So go ahead.
I just met him this morning for the first time.
That's
It's an initial. Well, we visited and his mother's here. And I've explained to them the gravity of the situation.
Oh, yeah.
He does appear to have had some mental issues in the past, but he doesn't appear to me to be incompetent at this time. So I don't feel like filing.
I think that would have been,
evaluation.
unless it's just a recent onset.
Yeah.
There are so many courts have dealt with this already,
Right.
and they would have been sensitive about dealing with capacity,
Yes.
mental capacity issues.
So
But I don't see anything that reflects he's been diagnosed as incompetent or insane.
I didn't see that from the visit I had this morning, but we've discussed with he and his mother that it might behoove them to try to hire an attorney. So I think they're going to explore that. This is a brand new case.
Well, you're a competent lawyer, but if they can hire it, then he's not, the taxpayers aren't going to pay for it.
So we're just asking for a normal reset to see if they could do that since this is initial.
Okay, I'm going to give you 5 weeks
That should work.
to talk to some people. If that's what you want to do, but this man's a good man. He's a competent lawyer, but you can hire anybody you wish. And if you are unable to financially, then the taxpayers will pay for it. But I always prefer people to hire their own if they can. But these are competent lawyers we have. So I'm going to reset in 5 weeks to get a lawyer or come back and see where we are on what direction this is going to head. Has an offer been made on this at all?
Yes, I have relayed an offer.
Well, I'm curious about it because of a criminal history like this.
10 years TDC.
Was there damage to the vehicles? Is there any restitution?
It was actually not her offer. It was Mr. Eckert's offer way back.
Well, it's an offer by the VA's office.
It is.
I don't believe we've been able to confirm the amount of restitution at this point.
All right, then please get a resetting. Thank you. And so Dylan LaFleur, Jose Rocle, those two have been reset. Durwood Stanley.
Judge, Mr. Stanley, we're trying to confirm that there's a death certificate. I believe this defendant has passed away.
Well, there is a Durwood Hugh Stanley obituary.
That's correct,
August,
Judge. We just haven't gotten the
2nd,
actual
4th,
certificate.
and that would be
She's going to give you the reset.
Yeah.
August 4th.
He's on that.
Well, so this is May 2nd, and that conforms with the date of birth in the indictment.
Mhm.
And he was charged with state jail felony and criminal mischief a year ago. And okay, so well, let's reset it a couple of weeks, but if y'all find out that it's
I'm hoping that I'll be able to find out today.
futile because of he's actually deceased, we can dismiss it.
Okay.
Yeah, thank
Thank
you. Okay, Cullen Cannon. I have 2 cases, right? Brent,
Yes, sir.
Mr. Turk on Cullen. Cullen Cannon, see?
Yeah.
You're Cullen Canton? Cullen Canton. Cullen Cannon.
Yes, sir.
All right, Mr. Cannon, this is an announcement. So we've already gone through an initial appearance, I guess. As you know, you were indicted on April 2nd in 2 cases. And they are numbered 25 CR 398 and 399, which similarly allege aggravated assault with a deadly weapon. And it looks like what happened. There was I guess your vehicle collided with another and 2 people were in the other vehicle and they were injured. Thus, the grand jury deemed that you were at fault by intentionally, knowingly, or recklessly striking the other vehicle. So you're looking at, if it were only that, in each case, no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. However, there's a prior conviction alleged out of Belmont County, Ohio in 2022 that states that you were convicted of failing to comply with an order or signal of a police officer, which is a 3rd-degree felony there, and aggravated possession of drugs. So if that were true, proven true beyond a reasonable doubt, you were convicted of one or both of these 2nd-degree felonies, your punishment is enhanced to a 1st-degree felony, which means you're looking at no less than 5 nor more than 99 years confinement in prison or life in prison. And up to a $10,000 fine can be also assessed. Mr. Kirk's a good man. He'll guide you through this obstacle course, but you have to recognize this is very serious. Anything with life imprisonment as a potential punishment ought to get your attention.
Yes, sir.
So today is an announcement. But you had time to make a determination.
Judge, we just got the offer. I now just got the discoveries and haven't had a chance really to go over it with Mr.
We
Kennedy.
give you 2 weeks.
Would you be able to get in my office within the next 2 weeks?
It's your life. You got to make it.
Yes, sir.
Figure it out. I'm going to give y'all 2 weeks. I'm saying that because the indictment now is 5 months old. You're still living at Port Bolivar?
Yes, sir.
Okay. And you have to understand if this allegation in the second paragraph is true, you are not eligible for probation in front of a jury. If you went to a jury trial, if you were found guilty, you'd be looking at no less than 5, no more than 99 years. I don't know if there's something here that is workable for probation, but you can only get it in front of the court through an agreement.
Yes, sir.
But we'll see you back in 2 weeks, okay?
Thank you, sir.
Sending.
Thank you.
And Camilla LeBeau is called in 25 CRA 49. And you were Miss LeBeau?
Yes, sir.
And Mr. Turk is your attorney, correct?
Yes, sir.
And in this case, ma'am, you probably know you are charged by an indictment here with the state jail felony of injury to a child 14 years of age or younger. And it says you struck the child with an extension cord. I guess that was some kind of discipline theory. And so you were looking at, if convicted, no less than 180 days, 6 months in a state jail, up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
I don't see any criminal history on this lady at all.
I don't think so, but I have not.
You still are on Sam and Selmo?
Yes, sir.
Okay. So
She does have some criminal history, Judge.
a conviction of a felony?
Looks like she
This is-
had a probation
Regular?
back in 2018.
Not injury to a child, is it?
She's advising that it's deferred.
How many children do you have?
I have one.
Okay. Well, discipline is, I grew up with it. And in the old days, there were unique forms of discipline that have been ruled unlawful as we were growing up. Things have changed,
Yes, sir.
and you got to be sensitive about it. Discipline is important because children sometimes have to be disciplined. But the parent is two things. You were a role model for the child. They're going to emulate you. Plus, you're in control of the child. They really can't do anything much to fight back. So you're in a dominant position, which you have to use your authority and power wisely and with discretion and reasonably.
Yes, sir.
So I mean, these are the kinds of things that are workable. Did the child have to go to the hospital or anything like that? Or I see the child reported it, it looks like, to authority, to somebody at school. But you didn't have to go, the child didn't need medical attention. Well, that's good. This ought to be fixable with a method of maybe, I don't know, here's the deal is parents, sometimes the parents need to learn a lesson, of how to deal with things in a responsible way because children are protected under law. They should be. They're vulnerable.
You do have the PC, right, Judge?
Yeah, I just read the first paragraph. Okay. This, according to the probable cause affidavit signed by law enforcement, was stating that the child exhibited injuries 12 days after the event. That's not good. But you got to figure out what the issue is and make sure that this can't happen again. Better ways of disciplining a child. Because under the law, children have great protection, and you harm a child, you have to pay serious consequences for it. Okay. We're going to put it on an announcement docket, 4 weeks. I have Logan Bertram and LaJuan Kirk. Looks like those are reset. Michael Stelly is next. John.
Yes.
Is that the only shirt you had,
Yes, it won't be cleaned.
sir? The only one? Yeah.
I clean.
Yeah, it's what goes on in here is the Constitution, and it's not a
Well, there's,
football game.
yeah, I didn't
You have your colors that you want to sport, you've got to kind of just look at everybody. You're the only one without a tie.
I know I was gonna wear my nice shirt, but I didn't have to.
Okay.
Or my nice shirt, so
Are you employed somewhere?
yes, sir.
Where?
With Chuck Mitchell construction.
What do you do? Field?
Yes, sir.
How much what do they pay you by hour?
$15 an hour.
Yeah, well, that's 35 to 40.
Yeah, we had to work, they don't always have to work. Construction, breaking that.
Construction of homes or other buildings?
Yeah, we build new homes and we do repair.
Yes, sir. Okay. Have you ever been in legal trouble before?
Yes, sir.
Well, there's kind of a honor in this room because of what we're dealing with. So dress nicely. Okay. All right. Here's the problem. Because of your prior convictions out of Hardin County and Jasper County for thefts, if you steal a pack of gum, it's a felony.
Yes, sir.
From here on.
Yes, sir.
So anything and here was tools of a value of less than $2,500, but still, you steal a pack of gum, they catch you, you're going to be looking at up to 2 years in the state jail.
Yes, sir.
That's just the way it is.
Yes, sir.
Live honestly. Harm no one. Give each person respect. That's the
Yes, sir.
fundamental rules.
Yeah, I'm in my, lessons in life.
Well, how's that working for you?
It's doing pretty good. I mean, I'm not really, not rowdy as I used to be. I guess you could say I got kids
Yes,
now, so I do pretty good in life.
Well, you're
Keep it
30, what, 36?
Yes, sir.
Yeah.
I still feel young at heart,
Well, You can be young at heart when you're 85, and that I think that's great. But just don't be young in choice making.
Yes, sir.
Don't make childish decisions.
Yes.
Also, you have children,
Yes, sir.
and you heard me. You're a role model.
Yes, sir.
They're going to emulate you. They're going to, and if they make mistakes, if they say, "I'm doing this because this is what I learned from Dad," whose fault is it?
Instead of children telling me like you're messing up, Dad, like you know.
I have children and now grandchildren, and I can't imagine how I'd feel if I felt like they were emulating me in a bad way.
Right.
So, but that's a natural tendency for children, and it's not their fault.
Yes, sir.
You've got a responsibility.
Plus,
Act responsibly.
plus, my daughter don't have her phone, so she's.
My God, well then what are you doing?
She only has me.
What are you doing in here? Did you have any business? You got
Yes, sir.
important. I mean, that's
That's one of the things kind of jumped on me, you know.
where are you in life? Number one?
Yeah.
No, you're not.
Not supposed to be. So.
No. Others are ahead of you. Your children, your family. You're third.
I got some garden on the table.
Good for you. That's right. Creators brought you in here, then then you, especially your children. But here it's theft, and it's not necessary. You got a job.
Yes,
You got children. Fix this. I'm sorry, John. I was maybe not where I went on there.
Just kind of.
Well, I thought a speech that needed to be said.
Your name's on the front out there, not mine, so you can speak all you want.
They hadn't torn that down yet?
Yeah.
What do we want to do?
Your Honor, he has a pending case in Hardin County still right now that I would like to resolve first because it's a little more serious.
What is it?
That is, what county is?
They said burglary habitation, didn't have the burglary building. So I'm innocent. I'm taking a trial, but it wasn't me, honestly.
Well, but have you been indicted for burglary of a habitation?
Yes, no, indicted. It's pending.
For habitation?
I'm not sure if it's.
Because there's a big difference. One's a state jail felony, the other's second degree felony.
I was arrested for habitation, and then when I got to over there, they told me burglary building. So I don't understand. I don't even know what I wasn't even around.
Well, technically, a habitation is a building, but the charging, a commercial building or a building that is not a habitation that's burglarized is treated as a state jail felony. If it's a habitation, it's more serious. Somebody's home.
Yes, sir.
A habitation is going to carry with it up to 20 years in prison.
Yes, sir. Oh,
There you go. These are things you got to fix.
Yeah, and I'm an attorney in Hardin County as well, Your Honor. And I was wondering if representative here that's be on that as well.
All right.
So as soon as we get that
How
resolved,
much time?
let's do 4 weeks.
You got 4 weeks.
Get it
Get a resetting there. Yes, sir. And Damian Ross. Damian Ross. All right. 3 cases, right?
Yes, Your Honor. Yes.
Is there announcements?
Yeah, Your Honor, there's an offer on the table. I'm confident that we're going to accept unless time to talk over with his family and decision. We can get a couple weeks.
We have 2. All right. Please get it resetting. Devontae Jobert?
Did you have to your format approach? Yeah.
Yeah. Was that a beer?
I wish.
I heard a,
Sorry, I'm moving a little slow.
I heard that. I recognize that noise.
Right there.
And we now call 23 CR 168 for State of Texas versus Devontae Jobert. You're Mr. Jobert? Okay. And today we have Mr. Packard is going to represent you, correct? Okay. You're retained on this one? I am. We set you on probation. Good Lord. Earlier this year, we put you on regular probation, right? 10 years in prison, probated for 10 years, and $1,000 fine for the 3rd-degree felony of evading arrest or detention with a motor vehicle. And that was on January 28th this year. Now, there's a motion to revoke probation that alleges, and this was filed, by the way, on September 15th. Oh, it's fresh. Just a couple of days ago. That you, number one, committed the offense of operating a motor vehicle while intoxicated with a child under 15 years of age on or about August 30th, 2025 in Jefferson County, Texas. And that's serious. Two, you were at a location other than your residence at 1:08 a.m. So you busted the curfew, I guess, on your probation order on that. Failing to abstain from the use of any and all intoxicating substances, including alcohol. And this is in conjunction with allegation of the DWI alleged earlier. And finally, it is alleged you failed to pay court assessed fees as directed, and you are behind or in arrears in those fees, which is also a violation of probation. So there's 4 reasons that have been placed in this motion that's alleged. The motion is viable, and it's alleging and pleading that a hearing be made, and we will do that to determine whether your probation should be revoked or not. Let me look at something.
And I was just kidding. Wait, you can this. That's how's it going? You can go right and get lots of option.
What's the results of the blood?
Let's talk back to it, Judge.
No. Yeah, this is not a good set of circumstances here.
It is not, Your Honor.
Look at this. Looking at the public safety report like DPS provides, that we all look at now in determining the appropriate rules for setting bond in cases. This public safety report goes back to about 10 years now of criminality, beginning with well, there was an assault, a misdemeanor assault, but he does not have a finality to it. Then in 2016, theft, 1 year probation, aggravated assault, felony. And it says disposition modification, probation 1 year. So it must have been reduced somehow. It doesn't say what location. Then we have an unauthorized use of a motor vehicle, state jail felony, which was adjudicated.
What year is that, Judge?
16.
Right, so that's when he was a juvenile. Your PSI reflects that
Was he treated as a
robbery was changed to a theft from person at the same time with the unauthorized use, and he was given TYC commitment of felonies that could be used to enhance his punishment.
2019, we have a robbery, a second degree, 10 years probation. Are you still on probation for that?
Oh, sir, I won't get to you.
Your probation was revoked?
Yes, sir.
Mhm. I've got a misdemeanor class B theft in 19, another that was resulted in probation revocation.
That one reflects, Judge, that was out of Orange County, where he was given 15 months probation. It was revoked, and along with
180 days is what he gets.
with 11 other misdemeanors, he was given 180 days on that.
Okay. And those misdemeanors are a series of thefts.
They're all thefts except for one evading
Evading
arrest.
arrest. I'm sorry, a criminal trespass as well. Then we've got in 2022, a third degree felony of evading arrest, 10 years of probation, which I guess is going to be this offense. Huh?
That's this offense, Judge, but that arose out of two events where he was found guilty of indecent exposure. He got 60 days jail time. So those were events that he was doing out at Lamar that resulted in he was actually running from the police officers whenever this was, the warrant was outstanding for those indecent exposures.
Okay. And then we have this case.
Yes, sir.
All right, Mr. Faggard, as the defendant's attorney,
Yes, sir.
give it your best shot.
Okay, Your Honor, while his record is bad, I want to bring, he's going to request a bond. He's currently employed at two different jobs. One is working for Williams Brothers Construction. He also works for Bubba Auto Sales LLC on the side. He has, he's agreeable to, I would understand the court's concern about letting somebody out with a DWI without some type of scram device or other ways we monitor his movement and conduct. He's certainly willing to do that. He understands that he needs to get help for the drinking. He's agreeable to go, if the court agrees to it, to go to the JCDI program or any other program that he needs to get help so he can get out of this cycle that he's been in. He has the ability to make a bond. He has a bonding company that is on standby. And most importantly, Your Honor, there are two, he has ties to the community here. He also has the support and mentorship of Pastor John Adolph over at the Antioch Missionary Baptist Church. Antioch. He has been mentoring this young man. He sees a lot of good in him. Everybody's trying to work with him to get him out of this life of crime. Also, Your Honor, before the warrant for his arrest was issued, he'd been meeting with Rod Carroll on a daily basis about the need to change his life, to move forward. He certainly, I believe that with some good mentorship and some good directions and some supervision by the court on, you must do this and you must do that to maintain sobriety and never drink again or never violate your probation. I think there's really hope for this young man. So I'm going to ask the court to take all that into consideration and set a bond for him that he'll be able to make with it whatever appropriate conditions the court may wish to impose as far as monitoring, no drug use, attendance at outpatient programs, things of that nature. Because we'd like to keep him on bond until we see if we get all the other case resolved, the new case as well.
I was promised all that before I reached the agreement back in January. And the whole Pastor Adolph card and all that stuff.
It's familiar.
They came with me about that. I wanted him to go to the prison for what he did originally on this. And so I'm standing here with egg on my face because I gave him an opportunity, and I'm not going to agree to releasing him at this stage, Judge.
Yeah, nobody should ever be embarrassed for trying to help a situation and give somebody a fair chance, which is what I did when I placed you on probation. And I stuck my neck out with your rich criminal histories. You have, here's a couple of things. There is no bond right now. I want to wait. This first question I'm going to ask you. You told the police when they stopped you here in this probable cause affidavit, and you admitted to drinking, and you told them you drank 2 beers, correct?
Yes, sir, I did.
You're standing by that?
No, sir. I went up.
You lied?
Yeah, I went up there and I admit I spoke with Chief Roy Perry and I told him the truth.
You didn't, yeah, the probable cause isn't done by Chief Carroll, though. It's by somebody else who did this probable cause affidavit. But why would you lie to the police at the scene?
Because I don't want to go to jail. And it's just being honest, but I'm still
You
feeling.
think lying is going to get you out of trouble?
Oh, sir, I'm not.
How much did you drink?
I'm gonna be honest with you.
No, really, you promise?
Yeah, Your Honor.
You should have been honest the whole time.
I
Can we
drunk.
swear him in?
Raise your right hand. Do you solemnly swear or affirm any statements that you may make will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hands, sir.
I drunk.
And you don't have to say anything
Yeah.
if you don't want. If you don't want to,
If you want to, this can be used
And-
against you later. No, it's a preliminary hearing.
it can always, anything that's
Okay.
that's
It can be used
freely and
against you.
voluntarily made
Yeah.
is always admissible
Man,
to against
I
anybody.
ain't fighting, bro. I'm wrong. I'm wrong. I'm just trying to get it close from this.
Look, I'm gonna wait until the blood tests come back before I make any decisions on what direction this is going to go. Do you have any idea when we expect a result?
I haven't seen the paperwork yet, Judge, and I checked again this morning.
2 weeks? What does it normally take? I don't know.
I can make some calls and try to find out, Judge, but I don't want to hazard a guess at this stage.
Here's what I'm going to do. Is tentatively set it for review in 2 weeks.
I can find out in
See,
that time
that ought to
frame at
be-
least.
Give everybody enough time to get your positions of strength ready on where we're going to head here. But at the end of the day, the court has reviewed the public safety report, which is terrible. You are on regular probation in this court, which means you've been convicted already. And your choices and conduct are the determinations of where you go next on this probation. And you don't get a jury trial. It's in front of me. Now you have a right to a jury trial on any other new charges that may come about. But my guess is that this DWI is going to come out.
Yes, sir. It's a state jail felony.
And it'll end up here. So we got to wait for that also before the thing can be disposed of. But it seems, have you ever had any assistance medically for any problems that you've had in this rich criminal history of yours?
No, sir.
Well, what is just rhetorically, why are you here? You know, I'm not talking about the facts of it, but why do you, you've got children, you've got responsibilities. Why are you putting yourself first
It's like-
and not last?
It's like a demon I can catch off.
Say that again.
Yes, I gave you my copy, Judge. Thank you.
Go ahead.
It's like a demon I can't fight off, Judge. I'll be trying my hardest.
Sorry.
I said it's like a demon I can't fight off. I'll be trying my hardest. I know, man, I haven't been out of jail since I was 16 years old. I've been going to jail my whole life since I was 16.
But
Then I get out.
but choices have consequences. You
Right.
make the right choice, you get rewarded. You make the poor choice, you get punished. All of us that's the standard we all have to face. But why is it consistently the bad choice you choose? But it's like you keep putting your hand on the stove, and now you are just not putting your hand. You are embracing the hot stove because it's going to burn you. Now it's a rhetorical question to think about.
I think about it all the time.
How'd you do in school? Did you have poor grades or good grades?
I had dyslexia.
Well, that doesn't mean that you're unintelligent. Okay, there you go. That's something to start off with. You're capable of thinking correctly and making the right choices and analyzing issues and being intelligent in your thinking. Would you agree?
Yes, sir.
And you have the greatest. How many children do you have?
I have 2 men. I've been trying. Judge.
Wait.
I'm trying.
Once again, those are gifts. Those are precious. That their outcome, what direction they head in their life, is directly related to parental examples.
It's like I'm stuck in mine. I'm not gonna be able to pay this man. I'm gonna lose my job. Then I'm gonna be out with 14 lawyer and fight my life with him.
Well, isn't that what happens when you make bad choices? That's why, you know what? You're a smart guy. Why don't you think, I'm about to make a choice here. Is this bad choice going to result in problems that I'm going to have to deal with? Well, look, I'm looking at this. Intoxication and driving a 4,000-pound missile is trouble and it's illegal. And you've got a child that was bouncing around in the car without any stability, wasn't in a protection device. They found the child just free and loose in the vehicle, and then you're the first thing out of your mouth when the police talk to you was, "I have 2 beers," and we know that can't be right.
Yeah.
Because when the test comes out, it's going to show how wrong you are. But the police may have saved your life and your child's.
That wasn't.
Because you're on the highway doing 40 miles an hour, and all they got to do is a big rig drive over you, and we're all at your graveside. But everybody makes choices, and you have to pay the consequences. But here's the deal: you can always start from that last mistake and do better.
That man was sent me to prison. I already know he tired of dealing with me out. And man, I can sit in, I can talk as much as I want to talk. And that man is tired.
Yeah.
That man been saying me since I started.
Hey, once again,
Choices.
It's choices and the consequences. Just like, look, can you imagine what would happen to me if I fouled up? Well, I got to pay a price. That's why I try to make the right choices. He's a good man. He's going to help you. He's a very decent man. I know him. Take his advice. You're lost in the woods. He's going to try to pull you out of the woods. But let me just say, anticipate this. This is going to sting some. However this ends, it's going to end up stinging. But then it's how you deal with it, which is the test. Or you can just go over there, sit down, cry, and give up. And give up and walk away from your family and all those blessings that the Creator has given for you. Why don't you start from here and do the best you can be? Because I believe you're capable. then let's move forward from here. You got to deal with this, but it's what happens here on after that's going to be the test of your character, sir. How we deal with our problems, that's the real test. Are you going to fail, or are you going to be a role model for your children? And it's not too late to start. We'll see you in a couple of weeks where we are, okay?
Thank you. Yeah, I was going to, one of the reasons I wanted to get him out on bond was probably when I got paid, I was going to hire a mitigation person to look into his psychological background.
Yes, sir.
And my hands are going to be tied with that, and I will deal with him on that.
Well, all that's psychological and all, but that didn't have any, I don't think that had a lot to do with a DWI. That's choice making on alcohol, and that
I understand.
you can't say I've got a mental illness that keeps me. Well, I guess you can develop alcoholism, but you don't throw a child in the car and put them in harm's way.
Well,
okay, it's reset. We got a trial, and we'll see you everybody in 2 weeks.
thank you, Judge.
Yes, sir. All right. Again, this is a child and a sexual assault of a child case. So we're in trial because of the nature of the case. It will not be broadcast on YouTube. So we are dark until the end of the trial, and then we will go back live for the result of the trial when a decision is reached by the jury.
On a misdemeanor complaint that alleges that on or about January 29, 2025, the location of the Meyer store at 635, which one is this? Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, that you did commit the offense of retail fraud in the second degree. Do you understand the nature of those charges?
I do, yes.
All right. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
I do, yes.
All right. First question I have for you is, do you wish to be represented by an attorney?
Yes, I do.
Public defender.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Wallach, we would waive any further reading of the complaint. My client stands mute, and we would ask for an adjourned pretrial date, please, Your Honor.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Pretrial in this matter will be adjourned to
October 15th.
October 15th, 2025, 9 a.m. As to bond in this case.
No, in this case, people are just requesting no go to Meyer stores and standard misdemeanor bond conditions.
Thank you.
Not sure how long she's planning to be held at Monroe, so I'm not sure if we should do the cash bond or not.
Ma'am?
Yes, sir.
You're currently in the Monroe County Jail. Do you have an expected out date?
October 23rd.
Okay.
I've been here for about 6 months.
All right, and that, at that point, you will finish a sentence, is that the case?
Yes, sir.
All right. what I will do is I will set her bond at $1,000, 10%, so she's getting some credit for what she's there for. I'll order standard conditions, including no assault behavior or possession of any weapons. There's to be no use of any alcohol, recreational marijuana, or any illegal drug. She is not to enter any minor store in the state of Michigan.
Thank you, Your Honor.
Further comments?
No, Your Honor, thank you.
Thank you, Your Honor.
Thank you, Ms. Wallach.
Thank you.
Court does call the case, People versus Brandon Bobby.
Ashley Feltes for the people.
Good morning, Your Honor. David Chan, on behalf of Brandon Bovee, who's approaching the stand.
Your name, sir?
Brandon Bovee.
Okay. What are we doing?
This is the time and date set for a pretrial, Your Honor. We're trying to get Mr. Bovee into treatment court in Lenawee County. We're waiting for a spot to open. So if we could have like a 30-day adjournment. And I think the spot is going to open because I believe we have somebody coming from there, coming here into 14th District Sobriety Court.
Set it October 14th. 15.
1-5.
What did you give me last? 15? October 15th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will continue. I believe you received the community correction compliance.
He got his warning, and it was very clear and unequivocal if he has a missed test or a late test again, that he will be spending his time incarcerated.
And I know you explained to him that I only give one warning.
And he has had his warning.
All right.
Thank you, Your Honor.
Court does call the case, People versus Lawrence Pack.
Ready, Your Honor.
Ashley Feltes for the people.
Your Honor, good morning. Joe Simon on behalf of Mr. Peck. State your name. Go ahead and state your name. Lawrence Peck.
Thank you, sir.
Your Honor, we're here for an arraignment. With respect to that arraignment, we waive formal reading and stand mute.
Defendant, every way formal reading, standing mute. Court will enter not guilty plea.
And Your Honor, you may remember we were here last week for a PCC. This was probably supposed to be I shouldn't say supposed to be, should have been a companion matter to that matter. We adjourned that till October 9th so my client could be screened for sobriety court. And I'm asking to adjourn the pretrial for the same purpose. He's actually underway. We thought it was going to be a 14A court, but sobriety court, but because of his residence, it's 15th. So he's already made his arrangements. He's going to be screened by 15th District Court. So asking for an adjournment to maybe line up similar dates.
And he's set for October
9th.
Gotcha. You want, so the date after that would be October 15th. That would work.
Terrific. Thank you.
No objection, that's all correct. People like to be heard on bond when appropriate.
All right. Pretrial in this matter will be adjourned October 15th, 2025, 9 a.m. As to bond.
Your Honor, this is an OWI case, charges an OWI second offense. The prior is from 2023. There was no crash, but there is that prior. The alleged BAC in this case was 0.084. We are requesting electronic monitoring of some time, given that this is the second offense in 2 years. The reason that there's the companion felony case as well is that there's some RNO attached to the OWI, but we waited for blood to come back on the OWI. So the RFC and the drug got charged first, and then this case is at the same time.
And he's not on any testing on the felony.
Not that I'm aware of.
No, he has been screened and assessed. He's done his aftercare, but I told him to fully expect a referral to community corrections today. He's prepared for that because he's been abstinent, requesting a sober link, Your Honor.
All right. Bond will be set in the amount of a personal recognizance, $10,000 bond. I'll order standard conditions, including no assaultive behavior, possession of any weapons. I'll order there's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes.
I will order it also that the defendant report over to community corrections for placement on a sober link testing device. So it'll be 3 times a day. And I've signed that order.
Thank you, Your Honor.
And I'll have him head there directly, Your Honor. It'll take a little bit, I'm sure, but I'll have him do that while he's here.
All right, very good. All right.
Thank you, Your Honor.
Court does call the case of People versus Jason Eckley.
Ashley Feltes for the people.
Good morning, Your Honor. Robert Goldman, P81222, appearing on behalf of defendant Jason Eckel. Your Honor, defendant is appearing by way of Zoom this morning.
Mr. Echo, can you state your name, please?
Jason Eckel.
All right, got it. All right.
Thank you, Your Honor. This is a date and time set for a pretrial. I've had an opportunity to speak with the prosecuting attorney again. At this time, Your Honor, we've provided to the court a form requesting a final adjournment in this matter. We'd be asking the court to set this for a final pretrial conference. We are continuing to engage in deviation mitigation discussions in furtherance of reaching a resolution. If the court could schedule a final pretrial, we should be prepared by that date. If the court is inclined to set this for October 15th, that does work for defense counsel.
Jury final settlement conference will be set for October 17th, 2025, 9 a.m. Jury selection, if necessary, October 20th, 2025 at 8:30. Both of those proceedings are in person. Bond will continue.
Thank you, Your Honor.
Thank you. And just to confirm, Your Honor, you said October 17th?
Yes, the Friday. That's a final settlement conference day.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Melissa Hatfield.
Ash Phelps for the people.
Oh, I told you Mr. Bird would show up. No, he's gonna be late, but I didn't expect that late. But anyway, go ahead.
Good morning, Your Honor. Tina Saxon on behalf of Ms. Hatfield, who's standing to my right.
Your name, ma'am?
Melissa Hatfield.
Thank you. All right, what are we doing?
Your Honor, we're asking for adjournment. I just learned that there are two other videos that Ms. Feltes is going to try to get for us.
Correct statement.
That is correct, Your Honor.
October 15th, 2025. 9 a.m. bond continued.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Shanice Greer.
Ash Phelps for the people.
Ready? Jake, on behalf of Sheriff. Shanice. Shanice, state your name for the record.
Hi, good morning. I'm Shanice Greer.
Judge, today's time of tape for pretrial. Ms. Greer is in Judge Kunke's recovery court doing really well. I asked Ms. Kirsten Stample if we could get, if it's possible to get this misdemeanor into Judge Kunke's recovery court. She said she understands, but she can't do that.
Right.
So we're here today. So my client would just like to set a jury trial date.
Jury final settlement conference, October 17th, 2025. 9 a.m. Jury selection, if necessary, October 20th, 2025 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you.
Judge, what time is it? I'm sorry, the final settlement conference, 9?
It's the same every time we do it, Kellawald. You pick.
Judge,
which time do you need?
You being the considerate judge you are, I'm just asking the final settlement conference time.
9 a.m.
Thank you, Judge, for your patience. Thank you.
No, okay. Your sincerity is really getting to me. Is that it for you, Mr. Kellawald?
It is, Judge. It's been a pleasure being in front of you. You have a nice weekend.
I won't see you tomorrow.
Oh, yes, unfortunately.
Well, you don't have to look so disappointed. Court does call the cases of the people versus Brandon Nash.
Ashton Phelps for the people in both matters.
But do I have it?
So Mr. Flynn and Mr. Bernstein are both here, but not like
with us in spirit.
I mean, physically.
They were physically here.
I don't know what all that. I just don't.
They both kept it.
But they should. Okay. Were you successful?
I was.
Okay.
Sam Bernstein here with on behalf of Mr. Nash, who's in the hallway and was hoping for a moment to chat with him before he went on the record, if possible.
Okay. So you need me to pass these matters so that
If I could just chat with him for a moment. We haven't had a chance to meet yet, Judge.
And counsel, any other cases present also?
Yes, they're right there, Your Honor.
Why not? It's your case. It's your parent time.
Good morning, Judge Simpson. My name is Melanie Calderon-Lemus, and I'm asking for permission to practice as a student attorney. And
Do me a favor. Take a deep breath. All right. Relax. Despite what Sam or anybody told you, you're a very nice person. All right. So go ahead. Start again.
Good morning. My name is Melanie Calderon-Lemus, and I'm asking for permission to practice as a student attorney under the University of Michigan Civil Criminal Litigation Clinic. And under MCL 8.12.
You know what? Your professors messed us up. It's all their fault. So you just go ahead. We'll get through this. Go ahead.
So, and under MCL 8.120.
MCL?
Oh, MCR 8.120.
8.120?
Yes.
Under the supervision of?
Sarah Sallin.
Thank you. Good morning, Ms. Sallin.
Good morning, Judge.
Young lady, I think I asked you before where you're from, right?
Yeah. Yes.
It was Cornell, right?
I went to undergrad there. Yes.
Yeah. And where were you from?
Las Vegas.
That's right. Okay. All right. Are you nervous?
Yes.
Yes. Okay. Would you like an adjournment so you can also speak with your client, or ask the court to pass the matter so you can speak with your client?
Yes.
Good answer. All right. I'll pass these cases.
Thank you.
You did just fine.
Thanks.
Okay.
Yeah.
Court does call the case People versus Benjamin Kritzer.
Ashley Feltus for the people.
Good morning, Your Honor. Brant Lashinsky, P 4238, Public Defender's Office, on behalf of Mr. Kritzer is approaching.
Your name?
Good morning, Judge. My name is Benjamin Kritzer.
Did you almost forget? No, go ahead. Okay.
Your Honor, our assistant prosecutor and I had spoken this morning and yesterday via email. I've been recently assigned to Mr. Kritzer. We're going to ask for one adjournment so we might be able to consider a resolution in this matter.
That objection, I'll adjourn October 15th, 2025, 9 a.m.
Thank you very much, Your Honor.
Fine, continue. Thank you. I don't need these today. It's okay. Court does call the case of the People versus Justin Katarai.
Ashley Feltus for the people.
Good morning, Your Honor. Oscar Rodriguez for Mr. Katarai, who is available also on Zoom. Justin, can you say your name, please?
Justin Katari.
All right, what are we doing?
Your Honor, we are actually prepared to accept a plea offer. However, we did not get the police report, or this is on me, in time because we need to do it as a no contest plea. So we would like to adjourn it just for one more, as soon as possible. We could put the plea on the record.
I have a date before then, don't I? That's my next one. Yeah. Oh, that's right, because you wanted time off. All right. My next date, Mr. Rodriguez, is October 15th.
That'll do.
Okay, you don't have to. It's all Miss Weibling's fault. October 15th, 9 a.m. All right. Thank you. Bond will continue with its conditions. Court does call the case People versus Joseph German.
Ashley Feltus for the people.
Good morning, Your Honor, and may it please this honorable court. My name is Jay Dallow, P number 72879, appearing on with behalf of my client, Mr. Joseph German. Mr. German, can you please unmute yourself and state your name for the record? Unmute yourself first. You're muted.
Joseph German.
Thank you, Mr.
Thank
German.
you.
And today is a date and time set for a pre-trial on this matter. Mr. German, do we have your consent to hold today's hearing virtually instead of in person. Are you okay with that? We have your consent, sir?
Yes.
Thank you, sir. Your Honor, as I stated, today's date and time set for pretrial. I've been corresponding with Sister Counsel, Ms. Feltis, and I wanted to I want to leave the floor to her to see if we had submitted a deviation. I think we're close to resolving the matter. I yield the floor to Ms. Feltis if there's any offer at this point.
Well, that's not going to be stated on the record, but
Unfortunately, any offer would have to be reduced to writing, so we would not be able to enter it. If there was one available, which there is not at this point, that October 15th date does seem appropriate, Your Honor.
during this matter, October 15th, 2025, 9 a.m.
Thank you, Judge. Is Zoom going to be sufficient for October 15th?
You have to submit the form and then I will make a determination.
Regarding October 15th, may I respectfully request a 1 week adjournment from that to October? Let me see. I'm sorry. I can't even do 22. I'm in trial. Can we do October 29th to return on the 29th?
That's not how my docket works, but when is my next date after that? Limited for October 22nd. I could squeeze you in October 22nd if you can't be here on the 15th.
I would love to. However, October 22nd, I am going to be in trial. Your Honor, I will.
I'll adjourn it to November 5th, he said.
Yes.
It's without objection from the people.
No, none, Your Honor.
November 5th, 2025, 9 a.m.
Thank you so much, Your Honor. Pleasure to see you. And
thank you. Yes, sir.
Thank you all.
All right. Thank you. Court does call the case of the people versus Eric Hopkins.
That's for the people.
Good morning, Your Honor.
Morning, sir.
Robert Ellman with and on behalf of Mr. Hopkins. Mr. Hopkins, you state your name when you get up here, please.
Eric Hopkins. Thank you.
Your Honor, the people have extended an offer just this morning. My client does need a little time to weigh his options, so we'd be asking for an adjournment.
During this matter, October 15th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the people versus George Walker.
One more time for me, Your Honor.
No, I just did that on purpose.
Robert Ellman with and on behalf of Mr. Walker, who is present over Zoom.
Mr. Walker, can you state your name, please?
George Walker.
Thank you.
And Your Honor, I was recently appointed on this matter. I'd just be asking for an adjournment that October 15th date if you still have.
October 15th, 2025, 9 a.m. Bond continued with its conditions.
Thank you, Your Honor.
Thank you. That's it for me. Have a wonderful day.
You do the same, Mr. Ellman. Court calls the case of the people versus, is it Deja McCoy? I probably mispronounced that, but it's Mr. Birch.
That's the votes of the people.
And good morning, Your Honor, but please, this honorable court.
It's Deja, y'all.
I'm sorry?
It's Deja McCoy.
Deja, okay. That was nice of you to interrupt, Mr. Bird, but go ahead, Mr. Bird.
Oh, that's all right.
It's okay, it's okay.
We got a good relationship. But Brandon Bird, on behalf of Deja McCoy, Ms. McCoy, can you please state your full name for the record?
Deja Nicole McCoy RG.
Thank you.
Respectfully, we'd like to send this matter for a bench trial. Yeah.
A bench trial. Have you signed the form? There's a waiver form. We can get the signature. Ma'am, attorney has indicated that you wish this matter set for a bench trial.
Yes, Your
You
Honor.
understand that you have an absolute constitutional right to have the matter tried before a jury?
Yes, I do.
All right. You understand that by waiving that right, it'd be tried before this court without a jury present.
Yes, I do.
People also waive their right.
Yes, Your Honor, the people will waive bench. That should be fine.
All right. Based upon the statement of counsel and defendant, court will consent to have the matter tried before without a jury. Non-jury trial will be set September 29th.
Your, I have not had an opportunity to check the dates with my witnesses yet, so I don't know that I could accommodate September 29th.
Gotcha.
But what I could try for that date, if it doesn't work, I could reach back out if there's no objection from defense counsel. Just because I haven't, we didn't have a chance to discuss ahead of time.
Got it. Okay. That understood, Mr. Burke?
It's understood.
All right. September 29th, I'll set it, and then if you guys need an adjournment, then we'll deal with that. September 29th, 2025, 9 a.m. in person.
That's tentative.
Bond will continue its conditions.
So what is
Thank you, Your Honor. And, good afternoon. Good.
That's it.
Thank you, Your Honor. Court.
Okay.
Yeah.
All right, we'll see you tomorrow.
Yep, see you tomorrow.
Court calls the case, People versus Rick Artuso.
People.
This Honorable Court, David Burgess on behalf of Rick Artuso, standing to my right.
Your name, sir? Rick Artuso? Thank you.
Your Honor, today's the date and time set for an adjourned pretrial. He's being sentenced in front of, I believe, Judge Conlon. We'll see if he's there or on the bench or not. Saw him yesterday walking around, but on October 1st, Judge, and I just want to make sure that that's goes smoothly before we resolve this. Yeah, so if we could adjourn it until after October 1st, whatever day is convenient with the court.
There was a sentencing for Judge Conlon?
Correct, October
Okay, I want to make
1st.
sure.
Jonathan Emmons is handling the appeal.
October 15th, 2025, 9 a.m.
Your Honor, could I have, I'm in trial all that week up in Livingston County, so.
22nd.
Thank you, Your Honor. Appreciate it.
You'd rather be in Livingston?
No, not at all.
Okay, I'm just saying.
It's not a preference, Judge, it's just scheduled.
Okay, all right. October 22nd, 2025, 9.
Thank you, Your Honor.
Thank you.
All right.
Court does call the case of the People versus Jennifer Gallara. Two cases. 1328 is an arraignment. All right, go ahead.
Good morning, Your Honor. Marissa Boyles, P 86438 on behalf of Ms. Gallara. Please state your name, please. Jennifer Gallara.
All right. Ms. Gallara, before we get to that case, I have to arraign you on another matter. You are citation. You are also before the court on a misdemeanor charge of driving while license suspended, denied, and or revoked, alleged to have occurred on August 11, 2025. The location of Bemis Road in Pittsfield Township, Washtenaw County, State of Michigan. Do you understand the nature of that charge?
Yes, sir.
That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could also order your vehicle immobilized. Do you understand that?
Yes, Your Honor.
All right. First question I have for you is counsel going to represent you on that, or do you wish to have counsel appointed for you?
My counsel, Your Honor.
She'll represent you on that. You'll file an appearance.
Yes, Your Honor.
All right, very good. So as to the formal arraignment on that, she waives formal
Waive formal reading, stand mute.
Defendant waiving formal reading, standing mute, court will enter a not guilty plea. All right, got that. Set bond on that case. I will just set bond in that case at a $5,000 personal recognizance because she's under bond in the other case.
Thank you, Your Honor.
All right. Okay. So what are we doing?
Your Honor, if we could set both of these for the October 15th date, we're seeking a global resolution. So we're going to submit a deviation request and hopefully resolve things on that date. She also has a court date for her hardship license in about 2 weeks. So we're expecting that to be resolved by the October 15th date as well.
And Your Honor, for the record, that driving suspended case does constitute a bond violation. I believe we addressed it at our last hearing, but I wanted the record to be clear that the people are aware that that happened after she was arraigned on the OWI matter.
You did.
Because of the criminal activity.
Yeah.
All right.
But we addressed it last time.
All right, very good. So I will adjourn both matters to October 15th, 2025, 9 a.m.
Thank you, Your Honor. Thank you, Your
Bond
Honor.
in each case will continue.
Thank you, Your Honor.
Thank you. Let's call the case People versus Charles Peters.
Judge Feltus for the people.
Good morning, Your Honor. James Feifelsky appearing on behalf of Charles Peters, who's approaching. Please state your name.
Charles Peters.
Thank you. Your Honor, Ms. Feltus and I have been in plea negotiations. She'd like a little more time to see my client on the sober link to possibly resolve this. So I'm asking for a brief adjournment.
Correct statement, Ms. Feltus.
That is correct.
I'll adjourn this matter October 15th, 2025, 9 a.m. Bond continued with its conditions.
Thank you. Have a good day.
Court calls the case People versus Reginald Sims.
Judge Feltus for the people.
Good morning, Your Honor. Justin Zaid appearing on behalf of Mr. Sims. President consents to appear via Zoom. Mr. Sims, can you state your name?
Yes, good morning, Your Honor. Reginald Sims.
Your Honor, date and time
Thank you.
set for a pretrial. I do intend on tendering a deviation request to the prosecutor's office. We are asking for that same date that you've been given out.
During the matter to October 15th, 2025, 9 a.m. Bond will continue. Counsel, you are in receipt of the court's order regarding his testing.
I am, Your Honor, and I understand there might have been an issue before I was retained. We spoke at length about that. It's my understanding he's in full compliance since then.
All right. Very good. That would be his only warning, however, if he fails to test.
Understood.
All right. Thank you. Bond will continue.
Thank you, Your Honor.
Thank you. That's all I have left, but Mr. Bernstein and Sal. But if they're not, can you go see? If they're not ready, tell them I'll call them up in the next block. Brown, good morning, sir.
Morning, sir.
You ready?
Sure.
Are you?
Yeah.
Terrapin, am I supposed to beat down on you like we did the house? Is that their mascot?
Yes.
What's the list?
Tigers.
LSU?
A little small school in Maryland.
We can't, the Towson Tigers, apparently.
They're in Baltimore. Shout out to the Tigers.
Somebody needs to shout for them.
They got paid. Check clear.
I need more time. They need more time. All right. Then I'll recall this up on the next block. At this point, court will stand in recess.
All right.
Attention.
Frauds from two different establishments. To leave the actual bond. People were to allow them to appear in person to address this bond. For the record, the people do not have a specific request as to bond. We're going to leave the actual bond setting in the discretion of the court, of course, but do want to make a record of a few things. First of all, these two cases do involve larceny. They involve retail frauds from two different establishments. The first one, the misdemeanor case, involves stealing about $700 worth of shoes from Dick's Sporting Goods. And the other case does involve stealing about $1,700 worth of alcohol and a few household items from minor. They happened about one day apart, as far as I can tell. And it's a concern of the people that the defendant was on parole absconder status at the time of those incidents. I'll also note that it is my understanding he has since become compliant with his parole. He is now back and being supervised by parole in Kalamazoo. But it's a great concern when we see things like alcohol and easily resaleable items like shoes being stolen. And I believe that if the defendant can be compliant with bond, and any conditions this court sets, that would be ideal. However, if there is any violation of bond, the people will be requesting a remand.
Your Honor, we would like to argue that although this happened while Brandon was on parole, he's no longer absconding, or while he was absconding from parole, he's no longer absconding. He has appeared in court twice now, over Zoom 2 weeks ago, and in person now, and has driven 2 hours from Kalamazoo to be here today. Also, Brandon has been very communicative with us and very responsive. And he, as we mentioned, he has many certificates that he's received, like front desk operations, to better his chances at employment, which he's currently seeking. So we would like to argue that. Thank you.
And Your Honor, I echo everything co-counsel said. I would just add that Mr. Nash did complete the KPEP 90-day inpatient program, and he stands before you today sober and proud of his sobriety and wants to continue that.
All right. Very good. With that information and with the information that was provided at the bench conference, I will make one change to his bond. I won't find that he's necessarily in violation of his bond at this time, given that all of those things have occurred that were brought to the court's attention. I will order that he is to test at community corrections. My understanding is he's testing with parole every other week. Is that correct, sir?
Yes, sir.
All right. I'm going to order once a week testing. Right. So there's going to have to be another facility that will do that. My initial order will be that you test every other week at community corrections. However, I will allow you to test at an approved facility in Kalamazoo. All right. So you'll be taking a drug test, short form, you'll be taking a drug test every week. All right. And testing every week. All right.
Yes, sir.
Okay. All right. So on the misdemeanor case, you're seeking an adjournment, counsel.
Yes.
I'll adjourn that to October 2025, excuse me, 9 a.m. And as to the PCC, is there a reason that we need to necessarily keep these together at this point, or?
I don't think so, Your Honor.
All right. What date would you like?
A 2-week adjournment or a 3-week adjournment would be great, Your Honor.
All right. My next one's the 18th. What, the 9th?
Sounds good. Thank you.
October 9th. Probable cause conference in this matter will be adjourned October 9th, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue, and that order, as I've indicated regarding community corrections, is going to be entered in both cases. All right. Thank you. When you leave here, I suggest that you go over to community corrections, check in so that you can do the intake portion. Okay. You're in town. Okay. Thank you.
Thank you.
Maybe just wait. I need.
Court does call the case, People versus Robert Moyle.
Conrad Siller on behalf of Pittsfield Township.
Good morning, Mr. Silla.
Good morning, Your Honor.
For what?
I show cause for failure to appear.
Your name, sir?
Robert Moyle.
And this is failure to appear for arraignment.
For arraignment?
Well, hold on a second.
So they said it for a show cause. This is actually a misdemeanor, able misdemeanor category. So I think they're to respond to the case.
All right. Sir, you have a citation that alleges that on or about February 20th, 2025 at location of Washtenaw Avenue in Pittsfield Township, Washtenaw County, State of Michigan, that you did operate a motor vehicle with an improper registration or plate. You understand that, charge?
Yes, sir.
All right. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs.
Yeah, I thought I was.
Understand that?
Yes, sir.
Okay, I don't want you saying anything about the charges. You're in custody now on something else.
I was coming for sentencing today. That's what I thought this was. So I was totally thrown off just now by you saying that.
Who are you going to be sentenced by?
I was under Colleen. He was under had a car accident, I do believe. So I wasn't for sure who the judge was going to be today, but I have sentencing today. I thought about
Conlon.
Conlon.
So, okay,
Yeah,
so you'd be downtown.
Yeah,
Oh,
see,
but-
it threw me off this morning. Yeah.
Right, okay. So are you represented by the public defender in that case?
Yes.
Do you wish to be represented by the public defender in this case?
I don't, it's probably gonna be time served with what I got going, I would imagine. I'm just took a plea for a year.
Well, I'm not promising.
Okay. Yeah, right.
So
Yeah,
I
I
also
will.
don't know if you're being sentenced on a felony.
no, yeah.
Might want to be careful as to whether or not this does something to your guidelines.
Oh, okay.
So I'll ask you again, do you want to be represented by the public defender's
Yeah, that's
office?
best.
Yeah, good answer.
Yeah, I think it's best.
Public defender case.
So Public Defender Natalie Pate with and on behalf of Mr. Moyle, we would waive any formal reading of the complaint. My client would stand mute and we would ask Your Honor for an adjourned pretrial date. And that would be all.
All right. Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned to October 15th, 2025, 9 a.m. Set his bond in this case at $1,000. I'll give a $1,000, 10%. Depending on what happens in the other case, you can let the court know. I'm just setting a nominal bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drugs. All right, thank you.
Thank you, Your Honor.
Thank you.
Thank you, sir.
Court calls the case of the people versus Salvatore Lorenzo.
Judge Feltus for the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Lorenzo, who's up there on Zoom. Sal, could you please state your name for the court?
Salvatore Lorenzo.
And I don't know if he's been arraigned yet, Your Honor.
He has not.
Well, as far as I go, ask the court to please waive reading, and he stands mute.
Defendant having waived formal reading, standing mute, court will enter not guilty plea.
As to the pretrial, I sent Ms. Feltus a letter. I think she's looking into it, and we're talking about a resolution and just need a couple of weeks to work that out, Your Honor.
What I will do is I'll adjourn the pretrial in this matter to October 15th, 2025, 9 a.m. Set his bond in this case at a $5,000 personal recognizance bond, standard conditions, including no assault behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drug. What was the BAC in this case?
0.168, Your Honor.
Any crash?
My notes have eluded me. I just have 1 second.
Yes.
There was not a crash in this case. The defendant was stopped driving on a flat tire.
All right.
But I would note for the court, there is a count 2 of attempted assaulting, resisting, or obstructing a peace officer attempt.
Understood. So just so that we're clear, I'm going to set his bond at $15,000 personal recognizance bond. I will order that the defendant report over to community corrections for a placement on the sober link testing. I've signed that order.
Good, Your Honor. We've talked about that, anticipated. He's taken a number of proactive steps in the case so far. So,
all right.
Thank you, Your Honor.
Thank
All
you, Your
right.
Honor.
Thank you. Court calls case people versus Gary Neptune.
Ashley Feltus for the people.
Nalepka.
Sam Bernstein for Mr. Nalepka, Your Honor. Nalepka, can you say your name to the court?
Gary Nalepka.
Thank you.
Your Honor, we're asking the court to please set this for a final settlement conference.
Jury final settlement conference will be set for October 17th, 2025, 9 a.m. Jury selection, if necessary, October 20th, 2025, 8:30.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls case of the people versus Ontario Robinson.
Ashley Feltus for the people.
Morning, Your Honor. Sam Bernstein with and on behalf of Robinson. Ontario, can you please say your report?
Ontario Robinson. Thank you.
Your Honor, in this case, my intent is to file a motion challenging some evidence. I'm wondering if the court has specific days that it prefers to hear such motions.
How long will it take?
Um,
It's a motion to suppress.
Correct, Your Honor.
All right. When can you have the motion, Tom?
Within the week, Your Honor.
All right. All right. You are filing a motion to suppress by the, by the 24th. Prosecutor's response will be due by the October 2nd. I'll set an evidentiary hearing if necessary on that matter. I'll set an evidentiary hearing for, I'm gonna need a Monday.
You're gonna need a Monday.
And I'm out one. It's gonna be the 20th.
That's jury selection in the morning, so we could do like 11 a.m. in the morning.
11 a.m.
Mhm.
So an evidentiary hearing for October 20th, 2025 at 11 a.m.
Thanks, Your Honor.
I may have a jury trial that day, Your Honor. I may not. I'll just
say here, isn't it?
My jury trial? No, it's a circuit court matter.
All right, well.
It's being a conflict. Reach out to me.
Okay, thank you. Makes sense. All right. Oh, one more thing. Sorry. A lot going on this morning. Mr. Robinson is asking that the court would please grant a travel request. He's hoping to go to Ohio from Friday of this week.
God sakes, why?
I
Go
know.
ahead, I'm sorry.
I tried to counsel him out of it, Judge, but I was unsuccessful. So he's consistent. But he'd be very much appreciative if the court would allow him to travel to Ohio from Friday to Sunday.
Of this week?
Yes, Your Honor.
For what purpose, you said?
I think his girlfriend has planned a trip for him there. He's on a SoberLink device. You can, of course, bring it with him.
Any objection for the defendant may travel to Ohio. When will he be coming back?
When do you think he comes back?
Sunday
afternoon, Your Honor.
So the 21st. So he can travel from the 19th to the September 19th, 2025 to September 21st, or yes, 21st, 2025. That's inclusive.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Jacqueline Murray.
Edward Jurgis for Jacqueline Murray.
Your name?
Jacqueline Murray. Mr. Jurgis and I had occasion to discuss this case this morning, and I think we're hopefully getting close to a resolution. I understand Ms. Murray is about to be sentenced into the 14B recovery court with Judge Washington.
Okay.
In the next couple of days. So what I'm requesting is that we adjourn this to give her a chance to do that, see how it goes for a little bit, looking at that October 15th date. And I wondered if the court would consider if Judge Washington releases her, just letting your bond convert to a PR to let her get out.
I will adjourn the matter to October 15th, 2025. I understand that. If Judge Washington releases her, counsel is to let this court know, and then we'll take the appropriate action at that time.
Thank you.
Okay, thank you.
Thank you.
Thank you. Court calls case people versus Keyshawn Jorgensen.
Right here. Ash Feltus for the people.
Good morning, I'm Charlotte Steffen on behalf of Mr. Jorgensen. Your Honor, I believe he's on Zoom.
Sir? Need to
Hey, how
state
you
your
doing?
name and get someplace at your stationery, please.
Yes, sir. My name is Keyshawn Jorgensen. I apologize. I'm at work, but I'm working over here right now. All right, I'm good.
Okay. All right, what are we doing?
Your Honor, he'd like to take it to trial, and so I would ask for trial and a final pretrial.
Final pretrial. Jury final settlement conference on this case will be October 17th, 2025 at 9 a.m.
Your Honor, I'm out of town that day.
Are you going to be out of town Monday if that's jury selection?
No, I'm not. Monday, October 20th. I'll be in
Yeah,
town.
so here's what I'll do. I'll put jury selection October 20th, 2025, 9 a.m. Otherwise, I don't get this tried to December. So I'll set the October 17th date. He'll need to be here, Frank. However, get with my office regarding whether or not you can appear via Zoom during that day. That will work for you, or that doesn't work either.
Are there any other days?
No, that's the problem. Otherwise, I do something else for you. Council approach, please. Very necessary to the 20th at 8:30. I think we found a way to take care of that. Both of those proceedings are in person. Bond will continue. All right. Thank you.
Your Honor.
You're welcome.
Have a nice day. Have a good day.
All right, thank you. Court calls the case People versus Benelli Cruz.
Carpenter on behalf of Ms. Cruz, who is approaching the podium and will be standing to my right. Ms. Cruz, once you get up here, please introduce yourself to the court.
Good morning, Benelli Cruz.
Thank you.
Your Honor, today's a date and time for pretrial. May we approach for Cobb's?
I know Cobb's, so I don't know why you'd approach.
Oh, I'm sorry, I didn't know.
Oh, you've been here enough. You should know. I don't.
I've never, oh, Cobb's, sorry.
All right, go ahead.
In that case, then, can we pass the matter?
I have, how many more do I have in custody right there?
13.
Well, I'll pass it. I don't know when we'll call.
Understood.
Take her back. Court calls. What's this person means? Court calls the case of the People versus Devin Julia Martinez.
Conrad Sullivan on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Martinez, who joins us via Zoom from the Washington County Jail. Ms. Martinez, can you please state your name for the court?
Devin Julia. I have looked my hair from.
Ms. Martinez, could you state your full name for the court?
Devin Julia. Meister Martinez.
All right.
Thank you, Your Honor. I'm respectfully requesting an adjournment. Ms. Martinez did indicate to me that she did sign up to be on the waiting list for the In Jail Dawn Farm program.
Okay.
She is being, in order to take advantage of the potential offer in this file, my client is being held on other cases with her next court date being the 29th on her felony cases.
Got it. Okay. Devin, I'm going to adjourn you out to October 15th, 2025, 9 a.m. Okay?
Thank you.
All right. Thank you.
Thank you, Your Honor. Thank you, Ms. Martinez.
Court calls the case of the People versus Abdurrahman Banda.
I'm supposed to people.
I'm appearing on behalf of Mr. Bonda. Mr. Bonda, state your name, please.
Abdurrahman Banda.
Your Honor, we're here for a bond violation sentencing. I believe you indicated that he could be released to treatment. We're still awaiting bed somewhere.
All right. Was there an order that was submitted regarding this treatment? I don't know if the PD arranged that or not.
I do show ones. Yes.
One was sent. Okay, so we're just awaiting a bed for treatment. All right. What do you want to do today then?
Set a control date in about a week. And then maybe
I
we can
really
take up.
don't have. I could. Yeah, go ahead. What is that?
So that would be at 1 o'clock.
On which day?
22nd.
What are we gonna know on the 22nd that I won't know? I mean, we're trying to get him into treatment.
Yes, Your
So
Honor.
I could come back in a week and there's no bed available.
He calls our office and I'm trying to make sure that he understands that we're on top of the case, that he's not just sitting.
September 22nd, 2025, 9 a.m. special time.
Thank you. Hopefully we'll have a word for you.
And I think if they contact Patrick, maybe they can figure something out.
Yes.
Court does call the case People versus Andrew Party. Chief Justice.
Conrad Siller on behalf of Pittsfield Township in both cases.
Good morning, I'm Charlotte Steffen on behalf of Andrew Party. Andrew, you say your name?
Andrew Party.
Assistant Public Defender Natalie Tate on behalf of Andrew Party, still on the case entry in, 1090.
Got it.
You want?
All right.
I apologize, Your Honor. I believe Ms. Steffen has been appointed to both cases. Is that correct? That was my understanding, Your Honor, but maybe I'm mistaken.
Do you have that?
I'm double checking.
Because I don't.
So I have her on case in 0621.
Correct.
And then PD.
Yeah. So he has two attorneys. All right. So what are we doing on these cases? Because I think the first thing we need to deal with is bond violation. Stephanie, did you get a copy of that?
I did, and I have had an opportunity to discuss that with Mr. Party.
All right, why don't we deal with that?
Sure, Your Honor. So he admits that he has tested positive for amphetamine. He indicates that it's left over from a prescription.
It would be a month and a half long period.
Yeah, that's a lot of amphetamines that he would get possession of. If what he's indicating to you, counsel, is true, Mr. Allen.
I have about 10 more left in my script.
There's also a cocaine positive test.
Yeah, I mean, that.
Yeah.
Yeah, it was in August 26th. Does he have an explanation for that?
No, Your Honor, he's denying use of cocaine.
He's denying the use of cocaine.
Yes, Your Honor.
So he wants a hearing on that?
Yes, Your Honor.
But he admits to the use of amphetamine without a valid prescription.
I had a scripture. I don't know what you're talking about. I mean, I don't have one. I don't have it with me here.
Is the amphetamine a prescribed medication that he's currently under prescription for?
So Judge, I think that the issue is that Mr. Party is saying that he was prescribed the medication.
They just cut
I don't know how old the prescription was. These were some pills that he was still in possession of from a prescription.
a couple months ago.
But is he currently under prescribed medication?
I've been taking Adderall since I was 7 years old, so it took 30 years. And this whole incident got me, my doctor cut me off cold turkey. It's just because of this whole thing, but I still had some
The
left.
doctor cut you off, so you should have been taking it.
Not because he doesn't want to be my doctor anymore. I'm not gonna, I got the paperwork. I'll send it to you. Just edit this guy right now.
Okay, just so that I'm clear, I thought we were talking about an old prescription.
It is.
So when did your doctor cut you off?
Couple months ago. It's more like he just stopped being my doctor. You know, got into a thing, and it's just now I have to get a new doctor, CMH, and they're telling me I'm like weeks out. It's not easy trying to get back into it. I had to go through counseling.
Let's try this way. When's the last time you filled that prescription?
It's a couple months ago. And I had my mom hold on to my pills while I was homeless for the time being. Now that I'm back to work and everything else, I've gotten back on them. I wasn't gonna wait till I started school again. It's not easy carrying those around. People keep stealing them. So yeah, I'd have my mom hold on to them. I feel like that's not a problem. I keep it at the house. I don't got a home.
What are we doing with the cases? I'll address this, Bob.
Your Honor, we are asking for an adjournment. We received some additional discovery yesterday, so we need some more time to review.
That's right.
I was going to be requesting an adjournment as well, Your Honor.
Witness matter to my next date of October 15, 2025 at 9 on both cases yes, the case ending, the seventh on which case? All right. And on that case, I'll set a bond hearing, or I'll set a bond violation hearing regarding the use of cocaine for that same date of October 15, 2025. I'll set that at 9 a.m. So he's not sure I quite understand, but I've got this cocaine in between the use of the amphetamines. Also, he didn't receive, he's indicating kind of the same thing, that he's on some prescription. This might have been avoided if it's indeed true. That he says he's currently on prescription, but then didn't provide documentation to community corrections. When community corrections then checked through their system, he's not currently prescribed a medication that would test positive for amphetamines.
Talking about the intake?
So if he's indicating that he gave that prescription to his mom, or that prescription does indeed exist, then he should have been able to provide it to community corrections, and he should have been able to provide it to the court. What I'm going to do at this time is defendant's bond is defendant's remanded. Counsel, if you can get that information to the court, then I'll reconsider that. Thank you.
What I can do, Your Honor. Thank you.
Get security down here, please. They've got folks in the back, so I'm not so much worried about that. Court does call the case of the people versus Ishmael Davis.
I just spell this for people.
Rob Brunpring on behalf of Mr. Davis, Your Honor.
You're good. You're good.
How you doing?
Okay. You can cancel that.
Yeah, I'm requesting a short adjournment in this case. There's several other matters pending and we'd like to do it global.
Give you my next date, October 15th, 2025, 9 a.m.
Thank you.
Bond continued. Thank you.
Your Honor, would you consider a release of treatment if he,
If they send over the order for release of treatment, I don't have a problem with signing that.
that's what you want?
Yes, sir.
All right.
Court calls cases of the people versus Heather Booth.
Conrad Solar on behalf of Pittsfield Township. In all four township cases.
And Assistant Public Defender Natalie Pate on behalf of Ms. Booth in all matters. Could Your Honor tell me if maybe Ms. Booth is present via Zoom?
Heather Booth. That'd be mandatory.
So Your Honor, I don't have I don't have an explanation for her failure to appear. I did speak to her on Friday of last week. And we had a very brief conversation and she asked if she could call me back. I did not hear back and I reached out to her yesterday and unfortunately was unsuccessful in reaching her. I don't have an explanation for failure to appear. I would request an adjournment for the record.
Bench warrant will issue for the failure to appear in all of these matters. Bond will be set in the amount of $5,000, 10% on each case.
Thank you, Your Honor.
Those warrants will issue immediately. She does, I think, have other warrants outstanding.
Thank you, Your Honor.
Court calls the case People versus Daryl Fredericks.
This is Public Defender Natalie Pate with and on behalf of Mr. Frederick, who's approaching.
Your name, sir? Daryl Frederick. Thank you.
Thank you, Your Honor. I'm respectfully requesting an adjournment. It's a my office issue. We do have all the discovery in this case, but we need to figure out a way to view it. I have been in contact with people in my office that we need to get this uploaded. It was sent over in a disc. Long story, but Mr. Frederick is being held on other matters. So we just asked for an adjournment so we can go over the video together.
October 15th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus T.R. Peterson.
Conrad Solar on behalf of Pittsfield Township.
And Assistant Public Defender Natalie Pate with and on behalf of Ms. Peterson, who should be present via Zoom. Ms. Peterson, can you please unmute and state your name for the court?
Yes, Sarah Peterson.
Thank you, Your Honor. As to, I guess I'll start with the easy case. So the case ending in 0918, the Pittsfield Township case, I'm respectfully requesting an adjournment. I have discussed this with Ms. Peterson and she is working on getting her license. So I'd ask for an adjournment of that case. And as to the other case, we do have a resolution.
We'll adjourn the one matter to October 15th, 2025, 9 a.m. As to the case ending in 0150, I have before me a plea form that indicates that the defendant will be pleading no contest to the charge of retail fraud, second degree, the 1-year offense. And then counts 2 and 3 would be dismissed. The defendant agrees to pay restitution as ordered by probation. That's the court's full understanding of the agreement.
Yes, Your Honor. That is correct, Your Honor.
Ma'am, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record, please.
Tyra Peterson.
All right, ma'am, it is this court's understanding that you are going to be pleading guilt or pleading no contest to the charge of retail fraud in the second degree. That is a misdemeanor punishable by a penalty of up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased 3 times the value of the property taken. If that is greater than $2,000, that would become the maximum fine. You understand that, ma'am?
Yes.
Do you understand what a no contest plea is?
Yes.
All right, 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, I do.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea?
Potential civil liability, Your Honor.
Ma'am, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form or gave your attorney authority to sign on your behalf after going through it?
Yes.
Do you have any questions regarding those rights?
No.
Look at paragraph 5 on that form are your trial rights. You understand that you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 23-18344. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, I do have to advise you that if you commit between today's date and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, any sentence evaluation, the court would no longer be bound by. You understand that?
Yes.
You also understand that you would not be permitted to withdraw your plea.
Yes.
All right. Counsel, have I complied with the court? Well, is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Not that I'm aware of, Your Honor.
All right. Have I complied with the court rule, and would it be proper to accept this defendant's plea?
We're satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 1. Counts 2 and 3 are dismissed. Pre-sentence defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
October 22nd at 12 p.m.
October 22nd, 2025. What time?
12 p.m.
At 12 noon. All right, ma'am, do we have probation in time? All right. So ma'am, I'm going to need you to wait on the line. Her bond will continue. I need you to wait on the line. We're going to put you into a breakout room with our probation department to get this process started, okay?
Okay, thank you.
Thank you.
Your Honor.
Court calls the cases of the people versus Brian Gerard.
Ron Brown, appearing on behalf of Brian Gerard. Mr. Gerard. Oh, there he is.
Hi.
Hi.
Your name?
State your name.
Brian Gerard.
Thank you.
Yeah, I'm requesting a brief adjournment. Global resolution. These cases may get dismissed and complete on some other cases. The prosecutor sent me a note about it.
That sounds great.
Adjourn this matter to October 15th, 2025, 9 a.m.
Thank you.
All right.
Thank you, sir.
Yeah, thank
Thank you. Court calls the cases of the people versus Christopher Minor. 3 cases.
Conrad Solar on behalf of Pittsfield Township.
Ron Brown, appearing on behalf of Christopher Minor, Your Honor.
Mr. Minor, can you unmute, state your name? You're unmuted, Mr. Minor. Can you just state your name?
Oh, Christopher Meyer.
Thank you, sir.
Your Honor, we were requesting an adjournment for further negotiation.
And he's being held on something else.
I believe so.
October 15th, 2025, 9 a.m.
Thank you.
Bond will continue.
Thank you.
Court does call the case of the people versus Paris Lester.
Conrad Solar on behalf of Pittsfield Township.
Now spell this for the people.
Ron Brown, appearing on behalf of Mr. Lester.
Oh, he's in right.
Sure.
Mr. Lester, there's an offer on the table. If you plead,
Your name, sir?
Harris Alexander Lester.
Yeah.
so if you plead in case 1034, they'll dismiss 1036. Is that what you want to do?
No, because what I understand is a global resolution.
I am not
Adjourn.
gonna do this on the
Adjourn.
record.
Yeah.
These
Adjourn.
matters are adjourned October 15th, 2025, 9 a.m.
Thank you, Your Honor. We'll come see you. You switch.
Court does call the cases of the people versus Matthew Wallace. Two cases.
Nash calls for people.
Conrad Siller on behalf of Pittsfield Township.
Matthew Wallace. Not here, Mr. Brown.
Brown Pring on behalf of Mr. Wallace, I have received a bond violation dated September 8th where there was a warrant request on a felony matter, possession of or use of fentanyl.
All right, so he's likely not to appear until we get him. Bench warrant will issue for defendant's failure to appear in these matters. Bond in each of these cases. Bond in each of these cases, take the amount of $10,000. I'll give a 10% privilege on that. They will issue immediately. Court does call the case of the people versus Montez Miller.
Conrad Siller on behalf of Pittsfield Township.
They got, we'll pass that brief. Everything's in custody.
Yes.
Got it. Okay. Miller's coming. Okay.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Miller, who is approaching the podium. Sir, when you arrive, could you please state your name for the court?
Montez Miller.
Thank you, Your Honor. Mr. Siller has extended a civil infraction offer in this case, which I did discuss with my client that he would like to accept. It is for double parking, and in exchange, count one would be dismissed.
That's correct, Your Honor. So I moved to add count 2 of double parking. You accept that admission, move to dismiss the original charge.
Yeah, Mr. Miller, do you admit responsibility to the fact that on or about August 3rd, 2024, at the location of Carpenter Road in Pittsfield Township, Washington County, State of Michigan, that you double parked a motor vehicle?
Yes, sir.
All right, court will accept that admission to count 2 double parking. Count 1 is dismissed. Fine and cost of $180. That will be due 90 days after release.
Thank you, Your Honor.
Thank you. I know who I got next. I need Steele next. Court calls the case of the people versus Safarius Steele.
Nash calls for the people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Steele, who stands to my right. Please state your name for the record, ma'am.
Safari Victoria Steele.
Thank you.
Thank you, Your Honor. As to the pretrial, I have discussed this matter with my client, and we are respectfully requesting to set this case for a final settlement conference and then to address bond when appropriate.
Jury final settlement conference will be set October 17th, 2025, 9 a.m. Jury selection, if necessary, October 20th, 2025 at 8:30. Both of those proceedings are in person as to bond.
Thank you, Your Honor. I'm requesting if the court would consider releasing Ms. Steele on a personal recognizance bond. I do acknowledge that this case was previously set for final settlement conference in February of this year, and there was a failure to appear at final settlement conference. My client
How
was
did she come back into custody?
from Wayne County Jail, Your Honor. I did have
So
confirmation.
she picked up something in Wayne County after this and then went there and was brought here on my warrant?
I cannot speak to what happened in Wayne County or about that case, but I can confirm that she was in Wayne County Jail from May 14th of this year to September 11th is when she was brought over on this warrant. That is correct, Your Honor. As far as the case, I don't know when that allegation stemmed from, but she was in Wayne County Jail from May 14th to when she was brought over on this.
Go ahead.
And that is all, Your Honor. We were just respectfully requesting if the court would consider a PR bond in this case.
I'm not going to release her on a bond. I've had to issue 5 warrants on this case already, and one was for final settlement conference. Well, actually, 2 of them were for a final settlement conference that she didn't show up at. I released her after that before. I'm not doing it again. Bond will
Thank you, Your Honor.
continue.
Thank you, Your Honor.
Court calls case of People versus Sherry Walker when you get it.
Judge Feltus for the people.
And Assistant Public Defender Natalie Pate with and on behalf of Ms. Walker, who stands to my right, please state your name for the record, ma'am.
Sherry Walker.
What are we doing?
Your Honor should be in receipt of the plea.
I am. I see. My understanding is that the defendant is going to be pleading guilty to the pleading no contest to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days. Upon a successful plea to that charge, count one would be dismissed. I got you.
Sorry, Your Honor.
No, it's all right. Count one would be dismissed and then defendant agrees to pay restitution as ordered, although that's on the formal checkbox. That's the court's full understanding of it.
That's correct, Your Honor. I apologize for missing the check box.
No, it's okay.
That is our understanding as well, Your Honor.
All right, let's have her sworn.
Right hand. Do you solemnly swear to affirm the testimony I'll give the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Sherry Walker.
All right. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of retail or no contest to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that becomes the maximum fine. You understand that?
Yes, sir.
Do you understand what a no contest plea is?
No.
Okay, I can't take her plea.
Understood, Your
I'll have
Honor.
to adjourn it out.
Okay, yes.
Well, no.
I'll adjourn this matter to October 15th, 2025, 9 a.m. I'll keep the plea for him, so if she decides to explain that she knows what she's doing, then I'll be more than happy to take her plea. Thank you.
The court speaking the plea form.
Yeah.
Thank you, Your Honor.
I probably need to do something with those because I signed off already on that. Court does call the case of People versus Jessica Yoder.
Judge Feltus for the people.
Ron Brown appearing on behalf of Jessica Yoder, Your Honor.
Her name?
Jessica Yoder.
We're requesting adjournment, Your Honor. I'm still in negotiations.
She's being held on something else, so.
That's my
Of your jail release, how do you plead? Not guilty? Okay, I'll get probation in here, then we'll have a hearing. You cleared all your warrants?
Yeah, well, clear everything.
When did you clear the last one?
The last one, they just scheduled it,
Call in Beth.
it was for Dearborn, and I just had to get fingerprinted.
What about the one out of Detroit from July of 21? Did you clear that warrant?
Detroit, I already got
Okay, so you want to have a hearing though?
it.
But you still want to have a hearing, right? Okay, so, all right. Okay, we'll get Ms. Wiles in here. She'll testify and we'll go from there, okay? Hernandez, Jose Charles Hernandez, file number 25W83953A and B. And also 5W839. I have 523A and B and 532A and B. Your name?
Jose
Jose what?
Hernandez.
You're charged with driving on a suspended, defective equipment. You're also charged with driving on a suspended and defective equipment on another case out of Brownstown that happened about 40 minutes, 30 minutes apart. You have the right to a lawyer. If you want me to give you one, I will. Would you like a lawyer?
Yeah.
Okay. You can go out in the hallway, he'll set you up with an attorney, and then either way, after you speak with the lawyer and the lawyer speaks with the prosecutor, you'll come back in front of me with your lawyer, okay?
I've cleared my suspended.
You can go out there and talk to the lawyer, and the lawyer will assist you, okay?
This way?
No, that's lockup.
Same way.
Recalling Lamar Eugene Thornton, 24B 702-123Y. All right. Your name, sir, again? Ms. Wilds?
Elizabeth Prosecution, Your Honor.
All right, so defendant pled not guilty to the charge that he failed to clear all of his warrants within 30 days of his release from custody. I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth. So help you God.
Your Honor.
Okay.
Yes, Your Honor. As far as going back, the defendant had several warrants out at the time of his sentencing. He was ordered to clear those warrants on August 18th, 2025. I did run Mr. Thornton's record at that time on August 18th, which is going to be the date of the show cause. Mr. Thornton did still have a bench warrant dated 11/4/22 out of 19th District Court. Looks like this was a false ID charge. He had another warrant dated January 3rd, 2024 out of 25th District Court. That was for a civil infraction.
Did he have one on July 6th and 21 out of the 36th? That's the only one I'm seeing on this clean printout, but it's dated September the 9th.
Yeah, and I did speak with Mr. Thornton. He was making attempts to clear those up. I am seeing one out of our court issued August 8, November 1 of 24 out of 23rd, November 1, 24 out of 23rd, again, November 1, 24 out of 23rd, and then, as I mentioned, January 3, 24 out of 25th, and November 4 out of 22.
Do you have this one, July 6th of 21? Driveway license not valid?
I am not seeing that one on my printout, Your Honor. I'm not even seeing that as issued even during his.
Well, let me hand you this lien printout here. Sir, do you have any questions of her?
For the most part,
Do you have any questions of her? Do you want to testify or do you wish to remain silent?
like to speak.
Okay, so if you're going to speak, this is a hearing, I'm going to swear you into an oath. Is that what you want? Sure. So this is a hearing, right? I'm determining whether or not you had warrants outstanding 30 days following your release from custody. She just testified. You said you don't have any questions. If you wish to testify, I have to swear you to an oath. Do you want to testify or do you want to remain silent? If you remain silent, I won't hold that against you. Do you want me to swear you to an oath? Sir. You can't just, you see that I administered an oath to her, right? You see me ask her to raise her. If you're going to speak now, I've got to ask you to raise your right hand and I'm going to swear you to an oath. Is that what you want?
It's like when you swear me, do I have to go against her or like, can I just say?
You can tell me.
Like, that's what I'm confused. I don't know if like I got to go against her or not.
What do you mean go against her? She thinks you didn't clear all your warrants. You pled not guilty. She just testified you had a slew of outstanding warrants 30 days after your, listen. I don't know what you mean by go against her. I've either got to swear you to an oath, in which case you're giving up your right to remain silent, or you can just tell me, Judge, I do not wish to testify. And I'll give you an explanation if you find me guilty following your decision on whether or not I had outstanding warrants 30 days after release. Do you understand? You want to testify? Okay. All right. So based on that testimony, I find that you violated probation.
In your honor, I just want to say the warrant that you're providing, Mr. Thornton does have aliases. It does appear that this one warrant that you have from July 6th of 21 is under one of his aliases.
Right. All right, I'm going to find you guilty of failure to clear all warrants within 30 days of release from custody. Now, listen, how many do you think you took care of? I need to know how many. Did you take care of one or 42? How many warrants did you take care of? 5. Okay. All right, good enough. I'm going to keep you on probation. Pay additional costs of $50. Clear all warrants by October 1st now. Do you understand that? Okay. So you just clear all your warrants, you pay $50 and we're done. At least with regard to this violation. Do you understand everything?
Yeah.
Okay, so can you pay the 50 now or do you need time? So you pay that 50 now. Remember, you got to clear all your warrants, including this one out of Detroit. Ms. Wiles, will you tell them about it, please? Show it to them on the lien. We can't give you a copy of the lien printout, but you can at least show it to him. And he can go over to Detroit and take that.
Absolutely, Judge.
Okay, take care of that. Good luck. Thanks. Corbett, Clarence Lee Corbett, the third, 25WA39 349A and B. We have a warning on a no proof. We have a drivewall suspended, an expired plate. Your name, sir? Corbett. You waived your lawyer previously. You met with the prosecutor. You were going to plead responsible to expired plate. You've got a valid license now, which is a good thing, with the understanding the drivewall suspend will be dismissed. Is that true?
Yes.
To the charge expired plate, how do you plead, responsible or not responsible?
Responsible.
Plea is accepted, suspends dismissed, fines cost $135. You go down the hall and take care of those. Do you have valid insurance?
Yes, sir.
Okay, good, good. Take care of yourself. You can pay the $135 now, right?
Yes.
Good luck. Right down to the cashier. Anything else down there? Lisa, do I have any sentencings on Zoom by chance?
No, not on Zoom.
Can what time are all these sentencing scheduled? Can I see the docket, please? Okay, I have a sentence with Hanley at 8:30. Are they here?
Gonna change channel. Funny docket, I guess. They do strong. They're they got to deal with this.
Is Mr. Crawford here today?
Yeah.
Destiny Henry, tell him I'm ready to go. What number does he have?
How much damage or less? So you're over. Yes. Yep, I got something for you right here. Hey, those are supposed to go to shine. I'll shoot now.
Hey, Vince, can you find Destiny, Mikhail Crawford and tell him I'm ready on Destiny Henry, please? Tell him I'm ready for sentencing on Destiny Henry. Thanks.
He's in the hallway. Oh. Are you in the front of the back office? Okay.
So currently Carmen's are overflowed in.
Is everybody from hallway in here? I mean,
It's in a hallway meeting, Mr. Crawford.
can I have that Hanley case, please?
This will be done again.
No, he doesn't have that. That's other. You ready, Mr. Shard?
I got thank you, Judge.
All right. Give me 1 second, okay? You go against Richard Allen Hanley Jr., 25W838-922.
Cedric Shard, on behalf of Mr. Hamley.
Good morning, Mr. Shard, and your client. Your name, sir? Okay, I'm just going to ask you to keep your voice up nice and loud for me, if you would, please. First of all, I do need to immobilize that motorcycle. So the vehicle needs to be immobilized. I just want to be clear. Did he already take care of that?
Yes, he hasn't had it, so
When I got out, I showed it to pay.
I need proof of that. You can't just ignore the orders.
I like your conversation with.
I need you to go to the Secretary of State.
Okay, I'll go there and get some saying that it's not registered to me.
Got to show the transfer. Defendant has, you can't just ignore orders. I told you to do that by September 17th. Defendant has until September 22nd to provide proof that the motorcycle was sold. So you have to go to the Secretary of State. You understand that, correct?
Yes, sir.
And you have to bring that back here by Monday, all right? All right, counsel, have you had a chance to review the report with your client? Are there any material additions, corrections, or deletions?
no, Your Honor. I didn't have a chance to review the report, but there's no corrections or deletions.
Okay, anything you would like to say on his behalf?
Judge, my client is taking this very seriously. He has been going to meetings regularly, as required by the court. He is employed, he takes care of his mother who has cancer, his son that's mentally challenged, and he's doing whatever he can to make things work in a positive way. He has no interest in drinking again. He's hasn't violated any conditions of his bond. We're asking the court to file a recommendation of probation. If any jail time is required, Your Honor, we'd ask respectfully to keep it at the end of the probation period. Make sure he can file the conditions of his probation.
All right. Sir, is there anything that you would like to say?
No.
Am I right that the only thing he had was the 2020? He did have one in Allen Park that was dismissed. It looks like it was nollie-prost in 17.
That's correct.
Then he had one in 20 in Wyandotte, the 27th.
That's correct.
And just. I'm just a little surprised they've got a recommendation of jail. Does he have any other criminal history? He doesn't have any, does he?
Not in the ticket, Your Honor.
Pardon?
Not even a cease speeding or a traffic ticket, nothing.
All right. Have I let everybody finish before I start? I just want to make sure. Okay. 18 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government that would change your address, your place of employment, or home telephone number. You must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs and ETGs as follows. Submit weekly for 2 months. If you're clean, we'll make it bi-weekly for 2 more months. If you're clean, I'll make it monthly. To continue attending 12-step meetings twice a week in person until you're in outpatient treatment. Once you get in outpatient treatment, and I am ordering outpatient treatment, you do not have to attend AA or NA any longer. You're to attend the Victims Impact Panel. That's one night put on by Mothers Against Drunk Drivers. You're going to continue your SoberLink device on your SoberLink until I'm going to make it December the 1st. You have until September 22 to provide proof that your motorcycle was stolen. I'm going to order that you serve 5 days jail credit 1. I'll let you serve those as follows. 3 days on our court work program. There's a $35 a day charge for that for a total of $105. And 1 day of community service. Community service, I'm going to give you until October 31. So your lawyer will explain that. But any place you have to do your community service at a location that is, it has to be a nonprofit organization, okay? This was a BAC, so cost of recovery is $150. Fines $300, cost $200. $75 victims' rights fee, $50 justice assessment, 6 1/4 screening fee, $60 for 685. You have probation fees of $360 for a total of $1,045. You have cost of recovery, which you'll pay through the court, of $150 for $1,195. Plus, you have the court work program fees. Your total's $1,300. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. And also, you may be eligible for early discharge if you're compliant after half the time. Okay, so after 9 months, if you're compliant, no violations within the preceding 90 days. Do you understand everything I've said?
Yes.
Can he pay all of this today, Mr. Shard?
Yes.
Okay, so you pay this now, you'll meet with probation, you fully understand the sentence.
Yes.
Okay. I wish you well. Good luck.
Thank you, Judge.
Thanks a lot. Have a good day.
Thank you, Ben.
Toscano, Bruce Laguardo, Toscano. Come on up here, sir. 25 W839605 A and B. Come on right up to the podium. Your name? Bruce what?
Bruce Lella.
Okay. Look, do you speak Spanish?
Yes.
Can you speak English or not? We're going to have to get an interpreter. So we need a Spanish interpreter, okay? So I'll reschedule this. Make sure you show up on time, okay? You understand what I'm telling you? Lisa, give him a new date. Are we doing October 1? Is that enough time to get somebody?
October 1st at 9:45.
All right, so you go right down the hall. You pick up your notice. You have to be back October. I get it. Yeah, I'm just rescheduling the whole thing for October 1st. And we'll have a Espanol interpreter. I understand. Go down and get your notice and come back in 2 weeks. Do we have a better way of communicating this? You guys have something down there, right, Lisa, or not? Am I dreaming?
I have a translator app.
Perfect. Yeah, tell them to be back October 1. I'll send them down. Go right down the end of the hall, John, walk him down, please, or have somebody walk him down.
1 second.
I don't know. He doesn't understand a thing. Do you know these people's names? Sir, what's your name there in the second row? Donald what? Hudson. I remember that. That's a sentence. You ready on one?
Ready on two, right?
Which ones?
Hudson
And,
Henry.
okay, where's Miss Henry? Is that you, ma'am? All right, let me take Mr. Hudson first. People against Donald Earl Hudson, 25W838-585B.
You want to run Mike Crawford representing Mr. Hudson? Mr. Hudson, please state your name for this.
Is somebody here from Clean Energy? Clean Energy. Do we have anybody out there, Lisa, that you can?
No, not on Zoom.
Let me call in Mr. Urick. Is he on 249? Boy, they were awful generous on this one.
Yes.
Morning, Your Honor. Can you come in, Ms. Urick, Mr. Urick, please?
Of course, Your Honor.
Thank you. Okay, tell me, I can't wait to hear. So he was charged with leave the scene of a property damage accident and improper plate. He drove into a fence. He pled to improper plate. So what's the good reason?
Well, there's no good reason for why it happened.
No.
The reason he left the scene.
Okay,
Reason he left the scene is because his boss ordered him to leave the scene. He was on the premises of the job, offenses for the employer. He went in and told his boss what had happened. Oops, there's accidents. They're like, great, get up there and work. So he drove off to work in a work car and came back. He left his car right there on the premises. The boss said he look out for it. I think they came and left it there, right? But they told it. Yeah, they told it. And they told it away. So he just followed the boss's orders.
well, the boss just can't tell him to commit a crime. Whoever your boss is has got a rock loose. Your name?
Good morning, Your Honor. May it please the court, William Urick on behalf of the city of Woodhaven.
Do you know if Clean Energy is going to make any kind of claim for restitution? We sent a letter to them. We advised them of the sentence date this morning at 8:30. You had on your STIP form, pay restitution, something to the effect, pay restitution is determined, or defendant responsible for any damage to property for restitution, I think it's saying. Do you know if Clean Energy is going to make any kind of a claim?
We have not had a claim as of yet. I can double check with Lieutenant Toller right now.
Would you do that?
Absolutely.
Okay, thanks. All right. In the meantime, I think we can go ahead because if there's no claim for restitution, I'm going to go ahead and check and see if. But let's just go forth with it and then I'll see what he says about restitution. What would you like to say on his behalf? Where does he work?
Stevens is an Amazon party.
I'm sorry?
Stevens, it's an Amazon freight department.
You got delivery driver, Your Honor. Again, he feels terrible about the situation, but at the time he felt between a rock and a hard place. He reported it to the authority on the scene that he knew about. He thought that it was stay expedited. And again, his boss said, okay, good for you. Get on the road.
What?
He didn't want to lose his job. He thought he could come back and get this thing resolved. But he's learned his lesson. Understands he can't do that.
Mr. Hudson, what are you, 62?
Yes, sir. But what I suggest to you, if he tells his boss, no, I'm not going to job, he loses his job, he waits for the police.
Well, he can't, I don't care what his boss tells him.
I know.
He can't tell him to commit a crime and then have the defendant come in here and say, I'm leaving.
Yes, Your Honor, I agree with you, and he understands that. And I was putting it was a state of mind that Bedrock, the boss, and said, get up there and get to
Tell
work.
Mr. Bedrock that the judge thinks he better reevaluate what he tells employees to do under certain situations. You understand what I'm telling you?
Yes, sir.
What's wrong with him? What do you want to tell me? Anything?
It's ready to get this soul. You know, you should know my client.
He still has warrants too.
Yeah, you know, he's got a few things he's got to take care of, but because of his matter, his inability to lead the state, he hasn't been working since his last school.
Well, I would have let him leave the state.
Well, he didn't mention that, Your Honor, that his job requires him to go out of state at the time. He heard the orders, followed it, told his boss to go out of state, so he hadn't gotten any assignments. So he doesn't have any money right now. He can't address anything. He's looking forward to get through this so he can start working again and pay his fines, to do his things.
Clean Energy has not articulated a plan.
Thank you very much.
Thank you, Bert.
This is gonna be the highest. I'm gonna find somebody who's convicted of improper plate. You should have known better. You needed to know better. You got warrants out for your arrest. You need to take care of those. I'm not gonna put you on probation on this, but you need to go over and take care of those warrants. I don't understand. You got a warrant out of Chelsea from 20, you got a warrant out of Taylor from this year, and another one out of 36th District Court that recently came to light on August 28. 100 fines, 200 costs, 75 victims' rights, $50 justice assessment, 4.25 or 60 days. Can you restitution to be handled through civil litigation? It was probably covered by insurance, is my guess. All right. How much does he have to pay today?
As I mentioned, Your Honor, he hasn't been working.
It's only been 2 weeks, though.
Well, you know, he has to start working, then he doesn't get a paycheck after.
All right. Tell me how much you can pay per week.
Well, the way these numbers work out, I guess it's approximately $15 a week because he's proposing to pay $15 a month starting the 17th.
What? $15 a month?
$50 a month, but you asked weekly, so I kind of did the math on it.
Well, wait a minute. How much does he make in his employment?
He makes $15 an hour, Your Honor. He's a married man. He's responsible for the household. He makes $50 an hour. It's not a lot of money, Your Honor.
How many hours do you work?
Well, 20.
A week?
25, yeah. Every about a week.
Why don't you get a new job?
Well, I gotta find one.
Well, go find one. $30 bi-weekly. I'll give you a little bit of leeway time. I'll start you beginning on October 8th. If you don't have the money at any time, you call the court, we'll go on Zoom, or you can walk in here on or before any due date. You don't need to be afraid. I'll be glad to let you do what you need to do. I don't want to bankrupt you. I don't want you to go without food or heat or anything else. Use your head, please. Okay? All right. And I'm serious. I don't care how many times we have to do that. If you don't have the money, you talk to me. Don't ignore me like you're ignoring these other judges in courts. You understand?
Yes, sir.
All right. Good luck. Destiny Danye Henry, 25W837-840. I want to know if there's a Jason Haney out there anywhere.
Morning.
Not on Zoom.
Representative, Ms. Henry, Matt Fitching.
Destiny and
He didn't show up. She just had one taken under HIDA. I'm not taking this under HIDA too. This is the same type of thing. So let's call in the prosecutor 249 and we'll go from there. There was a no contact provision in effect. I don't care if he called her up, said, come see me. I don't care what the situation was. You have no business having any contact with any victim here. None. You're violating court orders. I don't have anything on the restitution issue, so I'm going to have to ask Mr. Urick about that too. But here's the deal. I'm going to tell the prosecutor I'm not going to take this under HIDA. Counsel, your appearance again. I'm sorry.
Again, I may just believe right now, it happened in the city, what gave it on?
She had another case taken under HIDA for domestic violence. She pled guilty a month before this event. She was ordered not to have any contact. She went over there and picked this card. In violation of the no contact order. I'm just not going to take this under HIDA. I will allow you to withdraw your plea if you'd like. I need somebody to check on restitution on this one. It sounded like when I read the report, there would have been quite a bit of damage. And I recognize again that they made arrangements, the victim and the defendant, to speak, but that does not excuse your obligation to courts. You can't do these things. So that's how I feel about it. You guys figure it out. If you want, I will reschedule it and let everybody grab their bearings, and I'll reschedule it for or you can go talk and resolve it today, whatever you'd like.
Your Honor, I'd like to withdraw a plea and would like to discuss with the counsel. I'm sure we get it resolved.
All right, I'll just make a note. Told defendant will not take per HIDA. Defense allowed to and did withdraw a plea. So we're back to square one. Now, this case has been going on quite a while. So if it's not resolved today, you're probably going to have to set it for a final plea trial and a trial. Plea allowed withdrawn. Okay, ma'am? Thank you. All right, people against Craig, Alicia Marie Craig, 25W838685, A and B. Yeah, your name, ma'am?
Alicia, right?
You're charged with operating with the presence of drugs and drive while suspend. You have the right to a lawyer.
Yeah.
I'll be happy to give you one. Would you like a lawyer?
Please.
Okay, so we'll set you up with a lawyer. You'll go talk to the lawyer. And then either way, you're coming back in front of me today, okay?
Okay, thank you.
You're welcome.
You didn't do this one, did you? Yes, you did?
Yes. Yeah, that's all better. Do we have anything else out there right now, Lisa?
No, not on Zoom.
Well, I guess until something's ready, we'll get off here. Stay seated, everybody.
Okay.
Are we on record? Mohammed Khalid El Hazel, 25W839503. Good morning, Mr. Jadala.
Good morning, Your Honor. Sam Jadala, P62186, appearing on behalf of Mr. Al Hassel with the authority to enter into the proposed plea before this honorable court.
Okay, so this can be a plea to impeding. You're authorized to enter into that plea, true?
That is correct, Your Honor.
To that charge of impeding traffic, responsible or not responsible?
Having the authority to do so, we plead responsible, Your Honor.
I'll accept the plea 185. I can give them until the 24th. Is that good?
That'd be perfect. Thank you, Your
And
Honor.
the original charge dismissed. Have a great day. 185 by the 24th. Thanks.
Thank you. You and your staff. Have a wonderful day. Bye-bye.
All right. Aaron Stephen Franchuk.
Ready, Your Honor?
25W839726 A and B. Could I have Markel Ingram seated at the table? Good morning, counsel.
Thank you. Good morning, Your Honor. May I please court Radu Yakuban, P72819, on behalf of the defendant, Arlen Friendship.
Where's he at? Is he on?
That's Zoom, Your Honor.
Okay, so Aaron Franchuk, Lisa, can you bring him in?
He was on Zoom, but he's no longer out there.
Can you call your client?
Yeah, I'll take
Call your client. I'll go on to another case. As soon as he appears, I'll recall it, okay?
Thank you, Your Honor.
Marco Damon Ingram, 25W838641A. Good morning, counsel.
Morning, Your Honor. This sounds right on G87558 here on behalf of Mr. Ingram.
Sir, come on up.
Where's the photo?
Your name?
Marco de Ingram.
All right, so does he see me waive formal reading?
Yes.
Okay, not guilty plea is entered. We'll set it for a pretrial. He missed twice. Why?
Your Honor, my client is a financial market analyst and he travels a lot for work. He didn't even know that he had court dates. The second he found out that there was a warrant out that he had missed some dates, he contacted me and he flew back into town to get this taken care of.
Does he live still on East Jefferson?
No.
What's your new address?
Want me to say it out loud?
Oh, wait a minute. You put out the same one, 88106 East Jefferson, apartment 301?
Apartment D301, yes, that's what's on my ID, but I'm currently staying at my mom's house in South Carolina.
Well, who lives there? Well, what good would it be for us to send a notice to that address? On East Jefferson. You don't live there at all?
No, not anymore. Just moved out.
When did you move out?
My lease was up the beginning of August.
So we would have sent those letters to you in May and June. You got to show up. Okay, I don't want to hear this about work. Understand? You understand what I'm telling you?
Yes, Your Honor.
Don't play this game with us. Give me your address, please.
1643. Hillcrest.
Hillcrest.
Yes. South Carolina, Lancaster, South Carolina.
Lancaster, South Carolina.
Yes.
Zip
29720.
I'll still give you a personal bond. You can leave the state to go to South Carolina. So you can leave state without consent. You cannot violate a law. You must appear in court as directed. Counsel, if you guys want to do it on Zoom, I don't have a problem as long as he knows how to do it on Zoom.
Yes, Your Honor, but when we had contacted and reached out about that, it said we had to be in the same room to be on Zoom. Is it okay if we're in different locations?
I mean, I didn't know. Who said that? You mean my staff?
Somebody, yeah.
Well, because we didn't know that you were going to be. Where's your office?
Mine's in your room.
And he's in South Carolina. Yeah, that's okay. You guys can appear in separate rooms. October 1, at what time, Lisa?
10:30.
I'm sorry, for some reason, you're kind of cutting out.
10:30.
10:30. Okay, sir, go down the hall, get your notice. We'll see you guys back here. Anything else?
That's all you're.
Thank you. Is Franchiak out there yet, Lisa?
Bring.
Alicia Marie Craig, 25W8386885A and B. Is Alicia Craig here? Did you talk to your lawyer?
Yes,
Who's your lawyer?
I gotta tell you that,
It's Mr. Carmen.
Mr. Carmen,
Can you get him in if you would? Come on up to the podium, ma'am.
I was actually out there looking for him. I forgot to tell him something, but I guess I'll read.
Oh, there. Yep.
There it is. Why?
Yes. Thank you. He's on water.
There isn't original charge. I'm gonna take this back to you. I need some clarification on this one. Mr. Carmen, your appearance, let me call the case again. Alicia Marie Craig, 25W8386885A and B, your appearance.
Michael A. Carmen, 7384 on behalf of Clinton.
Ma'am, your name?
Alicia Craig.
All right, so today is the date scheduled for arraignment on an operating with the presence of drugs and drive while suspended, revoked, denied. For purposes of arraignment, how does she wish to proceed?
Your Honor, she'll stand here, wait the formal reading.
Okay, I'm entering a not guilty plea, ma'am. I'm gonna give you a $1,000 personal bond. She does not have any prior, oh yes, she does have a prior in 2020, right?
I believe that was out of state, yes.
Yes, okay.
I mean, it still counts. I just want you to know that,
No, it does.
okay? All right. $1,000 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no illegal drugs. You're not to purchase, possess, or consume any one of those. No contact with prosecution witnesses. Attend AANA at least twice a week in person. We're going to give you a form. You have to go in person every time you go. You have to have the form signed every time you come to court. You have to bring the form with you. So again, no alcohol, marijuana, or illegal drugs. AANA twice a week. No contact with prosecution witnesses. We're going to give you a new date. It's going to be what, October 1 again, Lisa?
9:30.
At 9:30, okay?
Your Honor, my client is prescribed marijuana for chronic pain and anxiety. She uses it 3 times a day. She's been prescribed since 2017. Can she use that while on bond?
Is that a medical marijuana card?
It is, but I believe hers is expired.
Well, I can't.
The only reason I did not renew it is because it became
Hang on.
legal.
I can't give you permission to use marijuana when you don't have a medical marijuana card. I can't do that. I mean, that's like me, the judge saying it's all right to do. No, I just can't. I'm sorry.
If she gets it renewed, it's valid, can't she?
Well, if she gets it renewed and you guys bring it up, I will certainly give her, ma'am, hang on.
I don't think.
Hang on. I don't think we should talk about this much now. You've got it looks like marijuana was the culprit here, right? Ma'am, let me just talk to your lawyer. I don't want you to say it. Well, I don't want you to say anything against your, right, against your interest here. It looks like marijuana was the primary culprit in this, right?
That's what's
So now
left.
you're asking me to say it's okay for her to use marijuana when she got charged with operating with the presence of drugs. I'm not doing it. Now, I don't overrule voters or the legislature, okay? She gets a valid medical marijuana card, you guys can renew your request, but this scares me. because you can't go out and drive around with it in your system like that. So that's what I'm doing. AA twice a week, no alcohol, marijuana, or illegal drugs. You cannot leave the state. You cannot violate a law. You must appear in court if directed. You're going to have to fill out a petition for a court-appointed lawyer going forward here. Okay, ma'am? Do you understand that?
No, I'll figure it out.
Well, this lawyers are appointed for arraignment. If the rest of the representation is based on indigency, so you have to disclose your income and fill out that form. I'll look at it. I'll be glad to appoint you one if you qualify. Okay? Thank you.
I'm sorry, Your Honor, what was the next court date?
October 1 at, what'd you say, 9:30, Lisa?
Yes, 9:30.
Yeah. Okay. Thanks. Aaron Stephen Francia, 25W8392766A and B.
Ready, Your Honor.
All right. Your appearance?
Good morning, Your Honor. May I please report Razuli Yakoban, P72819, on behalf of defendant Karen.
Sir, you have to start your video, please. There, and I'm going to ask you to take your hat off there. Tell me your name.
Aaron Stephen Franchuk.
So he's going to plead responsible to defective equipment.
That is correct.
And they're going to dismiss the no trailer plate, right?
Correct, Your Honor.
Is that what you want to do, Mr. Franchiuk?
Yes.
To the charge of defective equipment, responsible or not responsible?
Yes.
Responsible?
Yes.
I'll accept your plea, dismiss the original charge. And 125 is your total. And when I say dismiss the original charge, dismiss the no trailer plate, you pay 125. Can you pay that online now?
Yes, I can.
We'll take care of it today, Your Honor.
Thank you very much. Have a good day, counsel.
Thank
Take
you,
care. Nice to have you here.
Thank you.
Thank you.
Good to see you.
Jose Hernandez. I'm not clear on this one. I don't know whose this is. Mr. Urick, I'm going to need him, and I don't know who his lawyer is. Who's your lawyer?
The last guy that was over before was trying.
Come on up. Stay, have a seat right at the table here. Justin Robert Rodriguez, 25B148009. Justin Rodriguez, is he on Zoom?
No, I don't see a Rodriguez on the docket.
I just got this file here. It's just time to pay.
Oh, that's a time to pay walk-in.
Where's he at?
He had cases with Judge Hessen also. So you had to see the arraignment attorney.
Mr. Urick, I need you to clarify these. I don't think it's written up right. You got, it looks like you're dismissed. Maybe switch them around, but if the intent is to plead the no ops, you got to just fill out another form there. I don't have a problem, but okay. Noah Ryan Moore, 25W8391308. And B, is your lawyer here?
Yes, sir.
Come on in, Mr. Crawford. Your name's, come on up here and state your name, sir.
Your Honor, Mike Crawford, was proposed. Start station name for that.
No, locking.
Boy, I can't keep adjourning this. We've had at least 4 adjournments here. How many times are we going to adjourn it?
Well, this would be the final one, Your Honor. He got an appointment with the Secretary of State
To do what?
to try to remediate the issue. So he
All he's got is an expired license.
understand, but the prosecutor throughout the conversation become clear that he can take care of the issue.
Well, how come he hasn't taken care of it before? I arraigned him July 23. This is September. Why haven't you done this before?
I've been really busy with work.
Okay, so you got, I don't want to hear it. We're going to have to set it for trial. You want a jury trial or a bench trial? I'll give you a final pretrial, but I'm not going to keep rescheduling this. So do you want a final pretrial or a jury trial or a bench trial?
Bench trial. I'm sure we'll have it resolved someday.
Well, he should have taken care of this a long time ago. I need the prosecutor on this one. Sir, you have the constitutional right to a trial by a jury. Your lawyer tells me you wish to waive your right to a trial by a jury. If you waive your right to a trial by a jury, I will be the one who will solely decide your guilt or innocence. Do you understand that?
Yes, sir.
Do you wish to give up your right to a trial by jury? Anybody force you to do that?
Yes, sir.
Somebody forced you to do that? You understand a jury trial consists of 6 people that would be impaneled. All 6 would have to agree beyond a reasonable doubt that you're guilty of the offense charged.
Yes.
And you still wish to waive your right to a jury trial. I can't hear you.
Yes, ma'am.
October 1 will be the final pretrial, Lisa, at
9:45,
9:45. The trial date will be
October 15th at 11.
October 15th at 11 a.m. So I just want you to know on this one, Mr. Urick, your name,
Believe me, I got the city board name.
he's already had 3 or 4 adjournments. So I'm going to set a final pretrial on October 1. And do you have any objection to a bench trial, Mr. Urick?
None.
They've already waived it, so we're setting the bench for October 15th. That's the only reason. Well, Jen, thank you.
Thank you, Ron.
This, you don't understand what told her. That's correct.
What didn't you understand?
Did you want 2 NA and 2
2AA or NA?
2 NA or 2 AA?
Or a combination?
Okay, just 2 total weekly. And then, as far as the marijuana, I wasn't understanding because I'm.
Come on back up.
Come back up here, man.
Alicia Marie Craig, 25W386858 A and B. Slow down. You gotta slow down.
Can I get?
No, just slow down. Tell me your name.
Alicia Craig.
Like Carmen, B73824 on behalf of.
You can go to AA twice a week. You can go to NA twice a week. If it's more of a drug problem, you should probably go to NA. And you could go to any combination. I cannot permit you, I will not permit somebody who comes in here on a drug driving involving marijuana to use marijuana when they don't have a medical marijuana card.
That's not what I'm asking, Your Honor.
What are you asking?
I'm asking, I just would like to speak instead of being yelled at.
Am I yelling at
Not
you?
you, him, when he got upset, he's supposed to be working for me. I'm just trying to understand, you even talk to me. I'm asking if I come back.
Ma'am, let's back it down. Let's back it down.
Yes. I'm asking when I come back on my court hearing, when I drop, there will still be marijuana in my system.
You don't need to worry about that. You're making admissions
That's-
against, hang on. You're making admissions against your interests, which is what I just told you you shouldn't do. And I think your lawyer did, because all I know is they think in the citation that there was marijuana. Now, it was marijuana's involved. So why in the world would you come up here and start telling me you're going to test positive for marijuana? Don't do it. You're not a lawyer. I know we get at least 7 people in here every day that think they can be lawyers. They can't be. I've seen maybe 1 do it slightly average in my 31 years on the bench and 41 years as a lawyer. So you just gotta relax. Nobody's asking you to test anything right now. I never said you're gonna test.
No. Because I'm scared because of yesterday.
What happened yesterday?
I spoke 3 times a day that we had said, and I don't want to get in trouble. When I come back to court, I'm scared to get in trouble. You guys,
What happened yesterday? Do you know?
I spoke marijuana 3 times a day and
Ma'am.
that's all. And I just wanted to.
Ma'am, why are you coming up here and admitting this to me? You got a lawyer. Stop. Stop. Ma'am, just let everybody do their job here. Nobody's going to be unfair with you. Why would you come in here and tell me this on the record when you got a marijuana drug charge? A drug driving charge? You don't have any business telling me this. Don't tell me this stuff. I don't want to know about it. You tell your lawyer. And then he can tell me what he wants to say and what he knows is going to hurt you, not say, et cetera.
And Your Honor, that's why I didn't speak previously, that my client just used medical marijuana.
She can't use medical marijuana because she.
Today. It's been prescribed her since 2017 for back pain. And
That's great. She's going to have to get a medical marijuana card.
I understand. That's what I.
And then I'm still going to have some issues, but we'll see. I mean, I'm concerned about this. The more I hear, the more concerned I get. And you had one 4 or 5 years ago. You're gonna have a revoked license, ma'am. Ma'am, if you get convicted of impaired or OWI, you're going to have a revoked license.
Yes, sir.
You're not gonna be able to drive from here to that council table right there. You're not gonna be able to do anything except have somebody in the driver's seat and you push the car. Stop telling me these things. Talk to your lawyer. I did not say one thing about testing. You put me in a position where I probably have to order testing now.
I was just clarifying, sorry.
Your lawyer knows, he's been in here.
Sorry, and if I may, I just noticed on my schedule, I'm not here October 1st.
Well, whoever is going to be the lawyer here is going to handle the case.
Just want to clarify.
Okay?
Make sure that our lawyer gets his cover.
All right, thank you.
Thank you, Your Honor.
Thank you.
Mr. Crawford, you guys got to read between the lines. You think there's a big difference to me between I'm not doing a no contest plea on an MDOP and I'm not doing a 771 instead of a HIDA. She violated a no contact order. I'm not doing this. In regard to custody, no, I'm just not doing this. It's just not something I'm going to do. I mean, this was the same type of offense as far, no, I know one's assaulted, one's destruction of property. But she was on probation, just put on probation, and it is alleged that kicked the car and damaged the car. Now, I don't know what to tell everybody here, but I'm not going to take it. I'm not taking a 771. I'm not taking HIDA. I'm not taking anything else on this. I'm sorry.
Well, let's go back to the drawing board.
Well, you guys go back to the drawing board, but understand that's Cole Salmons, Cole B. Salmons, 25 B149145.
When you're out of my door,
Your name, sir?
Paul Salmons.
All right, so your client is guilty of trespass. He pled guilty. This is under HIDA. The agreement was for, I believe, I didn't write it down. I think he left it in my discretion. All right. Have you had a chance to review the report with him?
I have, Your Honor, and we have no material additions or deletion to the request. My client thinks it's reasonable, believes he can follow the order, the recommendation of the ex court to accept this.
Your name, anything else you'd like to say, sir?
No, Your Honor.
Stay away from Concord. You were trespassed from there. Stop going back there. Do we understand one another?
Yes.
6 months probation. They're recommending 12. I'm not going to do it. I will take this under HIDA. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. At the probation department, I should say, is directed. You're not to return to Concord Co-op. Do you understand that?
Yes.
We understand one another, right?
Yes, sir.
Okay. Now, don't make me tell you again. 100 fines, 50 costs, 75 victims' rights fee, $50 justice assessment. So fines and costs, I'm going to go light. They're only $275. Probation fees are $120. For $395, you have a screening fee of $60 for $455. You do 1 day of community service. I'm going to give you until October 25th to complete that. October 25th or 90 days. I'm going to give you a review hearing date in 6 months. If you're compliant, I will dismiss the case. You're to obtain and maintain employment and obtain a high school diploma or a GED. Son, listen to me. Are you listening?
Yes, sir.
Obtain and maintain employment, provide proof, obtain a high school diploma or a GED. That will help you immensely. You need to do that for yourself, okay?
Yes.
All right. You guys were talking. I want to make sure you understand everything. Do you understand what you have to do here?
Yes, I do.
What do you have to do?
To get a, you want me to?
Yeah.
GED.
And what else?
job.
Right, and what else? Not go back to Concord, right? Did I order community service?
Yes.
1 day by October 25th, and you got to pay a total here of $455. You go back to Concord, you and I are going to have a big problem. I'm going to give you a review hearing date in 5 months. So what are we looking at? Early February or something?
February 4th.
At 8:30 in the morning, you come back then, okay? Can he pay all this today?
He can't, he's gonna need a payment.
Can you pay $50 a week?
Yes, Your Honor.
I'll start at beginning on September 26th. If you need more time, you call the court, we'll go on Zoom, or you can come in, Your Honor, before the due date. Son, you need to be working. You're living with your parents, you're 22, you don't have a diploma. I'm not trying to make you feel bad, but it's time to pick it up here. Okay?
Yes, Your Honor.
Good luck to you. Wish you well. You'll meet with probation before you leave. LGM Pruitt, 25G82806. We're back on one of these again?
Good morning, Judge. Mr. Pruitt. Mr. Pruitt, state your full name.
LGM Pruitt the fourth.
This is a misdemeanor. Failure to respond to municipal civil infraction. This is unlicensed vehicle storage and $150 fine is what they wrote on the ticket. Is he going to stand mute and waive formal reading? Yes. Counsel, we've been going through this with Mr. Pruitt on a multitude of occasions, as I recall. I could be wrong. I think I've been out to your house before on an inspection, have I not?
Yes, you have.
Maybe twice, right? You're not going to make me go a third time, are you?
Judge, according to my conversation, Mr. Pruitt, the vehicle in question belongs to an upstairs tenant whose mother recently died and whose plates had basically run. At the time that the citation was issued, Mr. Pruitt was in Florida and did contact the individual who stated that he would take care of the vehicle.
How long you been in Florida? How long you been in Florida?
I try to spend 6 months.
I know. How long were you in Florida?
Till May 27th.
Then why in the world didn't you show up for your court date?
I didn't know I had a warrant out for my arrest.
Well, because you don't answer the citations. You get your mail forwarded to you in Florida?
This one wasn't forwarded. Guy upstairs.
There were not one, there were two.
Yeah. No, I didn't get one in Florida.
Did you get the one in Gibraltar? We sent two. Well, why didn't you show up? We sent you a notice for April 24th and May the 22nd.
Okay, still was in Florida. Bring it back by the 27th.
Well, it should have been sitting in your mail.
Shouldn't stay there that long?
No, I don't care how long you stay in Florida. You can stay in Florida all year if you want. But if you own the property and you get a citation, you need to figure out a way to take care of it. Come on, I don't want to go through this with you again, Mr. President Pruitt. I'm dead serious. I'm not going to put up with it. Do you understand me?
Yes.
It's ridiculous. This has been going on over there at that house for years. $500 personal bond. We're giving an early date. I expect everything to be taken care of. If it's not resolved by October 1, I'm setting this for trial. We're going to set it for pretrial October 1, right, Lisa, or not? Or Amy?
This is a Gibraltar case.
Yes.
The next day, that would be either September 25th or October 9th.
It's going to have it out of there by September 25th.
He's told me that the other individual did register the vehicle. There is valid registration. However, it was involved in an accident, which I believe he said may have totaled the vehicle.
Yes.
So it's not there anymore?
No.
Apparently not.
No. They're gone.
Did you tell the prosecutor that?
He's not here today.
Oh, this is just a walk.
Yes.
It's been taken care of.
Mr.
It wasn't my vehicle.
Mr. Pruitt. List. You had no business not showing up on this in months. They should have come over. You know what I would have done if I was in Florida? You said you got back here, did you not? On May the 27th. Did you not say that?
I got back on like May the 27th.
Today, as far as I can tell, is September the 17th. That's 110 days. Why didn't you come in here?
Didn't know I had a warrant out for my arrest.
Did you know that we'd scheduled court dates?
No, but I know it was all taken care of. While I was.
I know if I was the chief, I'd have had him come and pick you up. That's just me. You can't flaunt the system to prove it. I'm gonna give you that date, October 9th. We'll see if it's resolved. I hope it is.
Sure.
October 9th, Judge, or the first?
With this. I don't think October 9th at 8:30 is what I'm giving. You can go down the hall, get your notice. Thank you.
Okay.
And if you need to have a court-appointed lawyer, you're gonna have to fill out a petition for one. I doubt since you have a place in Florida that you're gonna qualify, right? You got a beautiful place in Gibraltar and a beautiful place in Florida, I'm sure. So you can fill out a petition for one, okay? Before you leave.
Petition for.
A court-appointed lawyer. You're entitled to a lawyer at the first court hearing, the arraignment. After that, you're not unless you're indigent. If you don't think you'll qualify, you can save yourself some time and not fill out the petition. If you think that you're indigent, you can fill that out. But I need to know all assets that you have, all income that you have. Okay?
Okay.
Good luck. Jose, Charles, Hernandez, 25W839-523A and B. And I also have 25W839-532A and B.
Like comment, be 738 support. That's the thing you're on.
Okay, I just am a little lost. He's got 4 tickets. Did he take care of the defective equipment charges?
Yeah, I fixed the light bulb.
Hang on, your name?
Jose Hernandez.
I'm asking your lawyer. You guys did not address. I've got a no ops on each. That's fine. And the suspend on each to be dismissed, right?
Correct.
But you guys didn't write down anything.
I believe we wrote to dismiss them on the second line there, Your Honor. He's dismissing the defective equipment.
I lost my mind. let me show you the stick. And first of all, for purposes of arraignment, does he stand mute and waive formal leave?
Yes, sir, he does.
You can approach. I'm going to enact guilty plea for purposes of arraignment with respect to this, Mr. Hernandez. You can come up.
I appreciate it.
Okay, and then I will take your plea to no ops, but I'm going to need clarification that I don't see anything about defective equipment.
You're right, Your Honor.
Can you take it back to him and have him dismiss those then? If that's what the intent was,
I'll be right back.
we'll go off the record. He didn't say this one.
Do you need that one?
Just bear with me, Mr. Hernandez. I'll have you out of here shortly, okay? All right. Okay. So now has he clarified that both defective equipment will be dismissed on there?
Yes, Your Honor. Separately for each file. I'm sorry, but
That's all right. You can have, sir, I want to be clear about this. So they've written those up where you are going to plead guilty on each file for no ops and that the defective equipment charges on both files will be dismissed. Do you understand that? Agree to that?
Yes, sir.
All right. So if you plead guilty to no ops, the possible penalties are up to 100 fines, 90 days jail costs, or all of those. And then I will dismiss the suspend. I'll dismiss the defective equipment and we'll go from there. Is that what you want to do?
So it includes jail time just for no ops.
Now, who said that? I did not say that. I have to tell you the maximum penalties. I've never sent anybody to jail, I don't believe, ever in my life on a no ops plea.
Okay, yeah, no, I plead guilty.
I know, but I want to understand, I want to make sure you understand. Do you understand everything I said?
Sort of.
Okay,
Kind of got lost it, but you told me the maximum's what I can give.
just you relax. You got 2 charges of driving on a suspended and 2 charges of defective equipment. Just driving on a suspended is 2 points. They're not going to have you plead to driving on a suspended. You're going to plead guilty to a 0-point violation code called no valid operator's license on person, which is punishable. The maximums provided by law up to 100 fines, 90 days jail, costs, or all those. Do you understand me?
Yes.
And then I'm going to also dismiss the defective equipment. You understand? Yeah. And once you plead, I'm dismissing the suspend charges. Do you understand?
I do.
All right, just relax. You're not going to jail today. Did you sign the advice of rights and read and understand the rights?
I did it.
If you plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that? To the charge, no valid ops on person, how do you plead? And I'm talking about on 523A file. How do you plead to that?
Guilty.
And to the other charge, 5. Hang on 1 second. To the other charge, 532A, how do you plead to no ops?
Guilty.
On August 17 of 2025, were you operating a motor vehicle in Woodhaven on Western Monterey at 3:08 in the morning? Did you have a valid operator's license on your person?
No.
And on the other case, 532A, on August 17 of 25, were you operating a motor vehicle on Western Island in Woodhaven at 2:39 in the morning? Did you have a valid license on your person?
No.
Are you on probation or parole? Anybody force you to plead guilty?
No.
Plea is accepted to no ops on each file. The suspend on 523A is dismissed. The suspend on 532A is dismissed. The defective equipments on 532B and 523A or 523B are also dismissed. How did he manage to get 2 suspend charges within 35 minutes of one another?
So I didn't fully tell him the story, but I was off like a 14-hour shift. I got pulled over on West and my girlfriend was just getting off work too, and she wasn't able to come get my car. Took about like 40 minutes for the first arrest to actually happen because they were being convenient and letting me move my car to the side, but my girlfriend had to move it, so they didn't tow it. Second time though, they left my car in the KFC parking lot, and I thought I would be able to like at least turn it around the block and put it in my aunt's driveway because my aunt lives literally right off the block from KFC. And the cop buried me in the KFC parking lot. I wasn't even able to leave Allen Road. Buried me in the parking lot.
Anything else?
Your Honor, I'm gonna ask for immediate sentencing, and fines and costs, to my client and give a little bit of time to pay, please.
Mr. Hernandez, you do the right things. This is silly. I can't believe you got, why didn't you have your girlfriend move the car over to your residence?
I wasn't really thinking straight. We seen them. They were waiting for us. Same cop, same officer was across the street waiting. I don't know. It was the dumbest thing I did. Like
100 fines, 50 costs, 75 victims' rights, $50 justice assessment, 275 or 30 days on each case. You owe 550. You can pay that now?
550. That's it.
Yep.
I can pay it.
I know, it's too easy, right? You think should I raise the fines? You don't think I'm tough enough? Is that it?
No, Your Honor, that's a lot.
I'm just kidding. I'm just kidding. I'm just messing with you.
He's not trying to play a game of chicken with the court.
Have a good day, Mr. Fernandez. I wish you well. Use your brains, will you? You got a lot of them. I can tell by talking to you. You got to use them though.
Thanks, Your Honor.
Good luck. Philip Devon, Gibson Perry, 25W839-417 A, B, and C. Is Gibson Perry here? Is he on Zoom, Amy or Lisa?
I'm not a co-host. If John could make me a co-host, I can look.
I'm just wondering why the file was sent in here.
There you go.
He's here?
No, I didn't check in the mirror.
Did Mr. What's,
I don't see anyone in Zoom or in Zoom, Judge.
Mr. Urick needs to write up a
It's a agreement.
request for a KPS or show cause.
Do we call in?
Yeah, I could just do it. We'll just do it that way. All right, so did he give you this file, John?
Is that from Mr. Urick? No, he probably just gave it to Deb.
Gibson.
Yeah, I don't have it marked, Judge. but I
Gibson
did-
Perry.
Don't know where that file came from.
So you had several rubber banded together. I'm wondering if that was rubber banded a couple others.
Well, that's what I'm doing on it, but I gotta get that case back to call it, so. I don't,
Do you need Mr. Urick, Ryan?
yeah. I don't know if he sent it in accidentally or he just forgot to write up the stip or the defendant's still in there.
Yes. Don't know why.
Can you hand me that back? All right. So I'm gonna call Philip Davon Gibson Perry, 25W839-417, A and B. Mr. Urick, I know we're going through this a lot today. Your name?
William Urick, I mean, you happen to say what it.
I don't know if you accidentally sent in this Gibson Perry file, but it was all of a sudden on my desk and it came in with the last ones, Mr. Hernandez. And I don't.
That was not supposed to be here, Judge.
Pardon?
I believe that's a Akron, Ohio resident who has not appeared.
Okay, that's what I wanted to make sure of. He did not appear, right?
Correct.
So I'm just going to go ahead and issue a show cause on the A file, suspend and default judgments on the B and C for failure to appear today. Thanks a lot.
No, thank you, Judge.
Do we have another one?
All 6 Davis files.
Okay.
Do you want me to bring those in now? He's the jailer. We had to get the police report squared away for his no contest, please.
Do we have a lawyer?
Mr. Crawford will be the lawyer. This is a 3 for 3. There's 3 in front of Judge Coleman Hessen that are being dismissed, and then Your Honor is hopefully taking.
What kind of case, what kind of,
These are all retail fraud.
why are we doing no contest?
This guy is.
Well, you will have to, let me see the file. I don't remember. Yeah. Retail fraud and theft offenses should never have no contest, please, unless there's a complete lack of memory. It's different on a assault case. It's different on. I have no idea.
Here are Judges 3, and here are the Coleman Hessens. Thank you.
Okay.
Mustafa Ishfaq Buta, 25W8387958. And B.
Michael A. Carmen, P7324, but I live in ground.
Good morning, sir. Your name? All right, so he stands mute and waives formal reading.
Yes, sir.
I'm entering a not guilty plea. I will set a bond. We're gonna set a new date though. So I'm gonna give him October the 1. What time will that be at, Amy?
Later in the morning for that, please.
I don't care. What time you want to do?
Yeah, what time? I mean, anything after 10 is open.
Can we do 11?
Are you retained or something?
I think I'm going to be, yes. And I'm not otherwise scheduled here that time.
As long as you're here by 11.
Yeah, you have Judge, you do have an evidentiary hearing and a sentencing at 11, 2 different cases with Mr. Buhanas.
We maybe go up 30?
If you guys show up, then I don't have a problem with that. Sir, are you, does he have any prior convictions of any kind?
Your Honor, yes, but no OWI or alcohol related offense.
Doesn't look like he has the greatest record in the. But no prior drunk driving or anything along those lines, substance abuse related, right?
One for marijuana a while back.
All right, $1,000 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I want you going to AA or NA at least one time per week. So you cannot leave the state. You cannot violate a law. You must appear in court as directed. No alcohol, no illegal drugs, no marijuana, no contact with prosecution witnesses either. I've signed your discovery order. We're setting it for 11 o'clock on October the 1st. Do you understand all that, sir?
Yeah. I'm trying to attend meetings.
You got to keep your voice way up.
No, this have to attend like a program.
Yes, AA one time a week or NA. You have to go once a week. Your lawyer can tell you different locations every time, and you have to go in person. And every time you go, you have to have that form signed to evidence that you were there. And then you have to bring that form to court with you every time you come to court. Do you understand that? You understand that, sir? All right. Go down the hall, get your notice. And we'll see you back here on that date. Thank you. Ramel Howard. 5838526.
Good afternoon, Your Honor. Michael Crawford representing Mr. Howard. Would you approach?
Your name, sir? So what are we doing here?
My client's going to be pleading guilty as charged under 771.1.
He's never had a conviction, it looks like. All these have been dismissed. All these. If you plead guilty here under 771.1, the possible penalties are up to 500 fines, 90 days jail costs, or all those. Do you understand that?
Yes.
Did you sign the advice of rights and read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all the rights. There will be no hearing or trial. Do you understand that? To the charge, resist and obstruct an officer. How do you plead?
Guilty.
Were you in the city of Woodhaven, County of Wayne, at 23300 Allen Road near Weston Woodhaven, July 23 of 25?
Yes.
What did you do? Did you avoid the officer and then kick the officer? Tell me what happened, nice and loud.
Sir, asked me to sit and I refused.
And then what did you do? Kick the officer then?
Yeah.
I can't hear you.
Correct.
Are you on probation or parole?
No.
Anybody force you to plead guilty? I'm gonna accept the plea. I'm gonna just set a sentence date. I'll take it under 771.1. I want to look at a couple things here. It looks like he should I just want to read the report, and I don't even know if it's in here. Was the police report in here?
It's not that file, but we have it. Get it for you right now.
I'm gonna take a plea. He should just send these in. I'm gonna have to get going here. So we're gonna have to do it on another day. I'm sorry. October 1 at 8:30 in the morning, okay? You go down the hall, get your notice, and I'll send you at that time, all right? I'm not ordering a preset report or anything, okay? All right, good luck. Antonio Trayvon Riviere, 25W838674.
Michael A. Carmen, P73824, on behalf of the defendant.
Your name, sir?
Antonio Rivera.
So for purposes of arraignment, does he stand me away formal reading?
Yes, Your Honor.
Pre-tried the case, he's going to plead to operating while impaired with the OWI to be dismissed. Is that right?
Yes, it is.
Is that what you want to do, sir?
Yes, Your Honor.
If you do that, if you plead guilty to that, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all 4 points, license suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes, Your Honor.
Did you sign an advice of rights form today?
Yes.
Did you read it and understand it?
Yes.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes.
To the charge operating while impaired, how do you plead?
Yes.
Were you operating a motor vehicle in the city of Woodhaven, County of Wayne on Vreeland near Pepperwood in Woodhaven at 1:05 in the morning on the 31st day of August of 25?
Yes.
Prior to that, did you drink alcohol? And if so, what did you drink and how much?
Yes, I started about 12 p.m. There was Michelob Ultras open.
How many?
Started at noon, probably like 12.
Was your ability to operate that motor vehicle impaired due to the consumption of the alcohol? Why were you pulled over by the police?
My front left headlight was out there.
Okay. And then ultimately you were arrested and transported to the police station, correct?
Correct.
Were you given a breathalyzer or a blood test?
A breathalyzer.
And were the results 0.137, Mr. Carmen? Do you so stipulate for purposes of...
According to the
Are you on probation or parole?
No, Your Honor.
Anybody forced you to plead guilty?
No, Your Honor.
Ever been in trouble before?
No, Your Honor.
Plea is accepted to impaired driving. The OWI is dismissed. I'm going to refer you for a screening and assessment. The only bond conditions are you cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs, and no contact with prosecution witnesses. I will give you a sentence date. And are we going to do that on the first two, Lisa? Or
Amy, yeah, we can do the first.
well, actually, Mr. Carmen isn't going to be here, right? Until the 11 o'clock?
Correct.
Let's just do it on August 15th.
October 5th.
15th at 8:30, is that okay?
Yep.
October 15th at 8:30, you'll be here, okay?
Okay.
Good luck to you. Thank you.
Thank you.
You're going to go down the hall, get your notice.
Thank you, Your Honor.
Thank you. Destiny Danye Henry, 25W83784.
Afternoon, Your Honor. Mike Hill Crawford, representing Ms. Hinton, who's approaching.
I have not done this in years, but I cannot take this bill for this plea. I'm not going to do it. Your name? I want to make sure I got this straight.
Yes, you are.
Domestic violence charge, item in front of Judge Heston.
Correct.
Sentence, no contact provision. Goes and ends up having a reasonable, has some kind of a discussion with the victim, kicks the car door, damages the car. Sounded like a significant amount of damage. I tell you guys I won't take item. Then you come back with 771.1. And now you're going to have me take a plea to a municipal civil infraction. I mean, I'm not blaming you. I'm just telling you, I'm not taking it. I will not take this unless there's a valid reason for it. What's the valid reason? Is she running for Congress? I mean, I'm dead serious about this. What,
The whole nature.
she already pled to destruction of property. And then we go back to 771. And I can't even read it. I'm not even sure I'm able to. Yeah. What is going on?
Well, the prosecutor and his officer with the great pains and stakes to try to find the best appropriate one that they
Get the prosecutor and the lieutenant in here, please. My Lord. And the lieutenant. Yes. I just feel like sometimes, and I don't want to be the bearer of bad news on this one because I see it all the time. Where's the accountability of it at anything anymore? She violates a judge's no contact there. Guys, I got to see you both in here, Lieutenant, and you guys, can I have your names, please?
Good afternoon, Your Honor. May I please call your
Sagan. Sorry, my ADHD. I seen him put the box of tissues down. What would you say, Your Honor?
He was calling the case. That's
Mr. Redkey is before the court with his counsel, Mr. Wendell. Mr. Hardman is here on behalf of the state of Ohio. Who's John Rye?
Mr. Rye is one of our prosecutors who handles juvenile court. He's going to be trying this with me. He's currently on paternity leave.
Gotcha. All right, we are here for a pretrial. We're going to reset this in 2-3 weeks, Mr. Wendell. Is that
Yes,
correct?
please.
Okay, give you an opportunity to get through discovery.
Thank you.
It's my understanding that you wish to be heard on the issue of bond.
That is correct, Your Honor. Thank you.
Go ahead.
Thank you. Judge, Mr. Redkey is joined in court today by his mother, Joy Gabriel. Judge, it's my understanding the current bond is $40,000. I believe also with provisions for either electronic monitoring or through monitoring through the county. Judge, we would respectfully request that the court reconsider that bond. It's my understanding Mr. Redkey does not have any prior felony contacts. I believe he has a very modest juvenile court record. It's my understanding, I believe there may have been a theft, which was a shoplifting matter out of Butler County. Other than that, I don't believe there's anything of consequence. Judge, this matter does arise from 2024. There's no relationship between the state's witness and the defendant. It's my understanding there would be certainly no issue with any stay away, no contact order. He certainly would comply with that. Judge, I think he does have a good stable residence at which to reside on 111 Boys Avenue, I believe, in Franklin. However, there has been some contact initially with the tenant there, and the landlord has become involved and indicated that he would not agree to electronic monitoring at the residence, apparently citing that no felons can be in the residence. However, not taking into consideration certainly Mr. Redkey's innocence and presumption of innocence at this juncture. So in light of those facts, Judge, certainly his mother is available and is available for you to inquire. I think his ability to make that a sizable monetary bond is non-existent. He does not have the present ability to make that bond, and I do believe that that is an appropriate consideration for the court to take into when setting bond. Thank you, Judge.
Mr. Hardman.
Your Honor, just first of all, with regard to Marcy's law, we were able to speak with our victim and serious physical harm. There was a pipe that was used as part of that beating that took place with regard to this victim. That was not wielded by this defendant as shown by the video that we saw. However, he was participating with hands with regard to the beating of this particular victim. He has known of these charges at least since July, because that was when, or at least the potential charges, because July of this summer, he was identified a little bit before that, but he did provide a statement to police as it relates to his involvement or knowledge of the charges. And I think he even knew slightly before that because of some involvement ultimately in the juvenile co-defendant who has been bound over to this court and is set for arraignment. That juvenile co-defendant is currently out on OR bond with EMHA for whatever that's worth for the court's consideration. We would at least like to see the defendant on electronic monitoring in order to protect the public and specifically this victim. But there also is a protection order that was issued at arraignment. So nothing beyond that.
So are you saying that the monitor is an impossibility?
My understanding, what Mr. Redkey has indicated to me is that the landlord is a required signatory, if you will, for the electronic monitoring. And he has declined or is refusing to do so, according to what Mr. Redkey is advising me this morning. That is correct.
And no other places will take me. I'm very remorseful.
Mr. Redkey, I would caution you not to make any further statements without your counsel's input, please.
Yes, Your Honor. I'm sorry. I'm just.
Your Honor, thank you. And I do appreciate Mr. Hardman's efforts to comply with Marcy's law. He was very gracious in doing that yesterday, so thank you.
Are we aware of any issues, substance use, mental health issues?
No, Judge. I have conferenced with Mr. Redkey about that. I don't believe that is a significant factor here.
I am going to modify the bond to a recognizance bond with electronically monitored house arrest. Mr. Redkey, if for some reason, again, and I don't know about checking with your landlord again, I think if you have a valid lease that you can show, do you have a written lease, ma'am?
I'm not. May I speak?
No, Mr. Redkey, you may not.
Just hold on. He's addressing.
No,
All right, so what?
But his name's not on the lease.
I understand. All right, at this point in time, I'm not going to modify it further. I will have court services look into placing him somewhere into some sort of residential facility.
Thank you very much, Judge. That would be very helpful.
All right, thank you.
Okay. We're going to get a court date in a couple, 3 weeks. Okay.
Yeah. Now just put release with EMHA.
So.
I mean, have the city, what hey,
Lieutenant Toller, David.
Guys. What do you think? Does anybody have any clue what I'm thinking? I want to tell you how I'm feeling. I take this young lady's plea. I read the report. I'm aware of the fact that she pleads to HIDA under 7694A. I'm sorry. Yeah, it takes a HIDA plea, I should say, on the domestic. Goes in front of Judge Simpson. He's ordered not to have contact. Has contact with the victim. Sounds like it was a mutual thing. He wasn't innocent in all this, but as you know, I don't order victims not to have contact. I have no authority to do that. They get into a dispute. She kicks his car. I take a plea under HIDA, unbeknownst to me at the time, that she just pled on a domestic in front of Judge Hessen for HIDA. I send it back saying I'm not taking HIDA. You send it back saying take it under 771. And now you guys are sending me a municipal civil infraction?
Ron, if I could speak to that.
I want to hear it. I got to tell you, I try not to get involved in what you guys do. I bite my tongue up here all the time on both sides. This is ridiculous. So yes, I'd love to hear it.
Your Honor, to begin with, I believe the court was concerned about accountability. The people believe that given the fact that she is on an active probation with Judge Coleman, so there may or may not be some form of a violation of probation, not required to be triggered by a conviction, but simply the contact issue. The second feature that developed.
There is no conviction now if I take this plea.
Correct.
There's a conviction for nothing.
And there wouldn't need be at a violation of probation hearing. The contact is a violation of probation in and of itself. As in real time this matter was developing, we tried to reach the victim again. So he has been hailed by the probation department and by us and has been non-responsive. These young people have an ongoing custody issue before the front of the court in the Third Circuit. This young lady, as I understand it, is well employed at a call center, I believe. And obviously the court has all the discretion to disagree with the people, but I believe that given the complexion of things as they develop, specifically with respect to the, what's the word I want? Inactivity or incuriosity of the victim in trying to shepherd this case, I believe that this was a reasonable outcome. Thank you, Judge.
And Your Honor, we obviously respect your concern for the violation of the first order, but as counsel stated, my thought process was similar. If Judge Hessen has an issue with it, she can be held accountable for that violation before that court not be penalized here in a separate subsequent case.
Guys. I must be missing some. So because I say I can't take this under HIDA, and I'm not going to because it was a domestic dispute, and she just pled guilty to and been sentenced on a domestic dispute a month earlier. And then you guys sent in the 771, and now you want to tell me Judge Hessen can revoke. Judge Hessen can take steps on her case. Number one, I don't care what people do. I made that abundantly clear. I don't think we treat people better. Call center, great. Lawyers, doctors, dentists, priests. I don't think we treat anybody differently based on who they are, what they do, who they know, or how much money they make. And I've said that for 30 years and I believe it. So let's throw out the employment thing. Let's not talk about her employment. Let's talk about something called justice. Let's talk about something called justice. Let's talk about something that has to do with holding people accountable. Giving them breaks when they're deserved. And everybody deserves second chances. But not in this scenario. I find this to be, first of all, let's just call it the way it is. Judges are not really legally authorized to tell people that they're not going to do something that the prosecutors are off. This used to drive me crazy when I was a young judge. Still bothers me a lot. Because there's no justice being served here. I just want you to know that's my feeling. And when I'm done doing this, I'm going to take this plea. I'm gonna take your plea, man. You're gonna walk out of here with something that is 99.8% better than what they offered you 2-3 weeks ago when you pled to malicious destruction of property. And the only one that called it was me. Because it isn't right. It's not right. I don't care what anybody. You could line up 150 prosecutors, they could all agree with him. 8,000 defense lawyers, line them up, they could all agree with me. I'm still going to be the one to say this is wrong. It's just wrong. It's just wrong. The idea that Judge Hessen can or cannot do something or should or shouldn't do something is part of this agreement I find to be hogwash. But the thing about me is I'm not going to overstep my bounds. At least I do my level best every day I come in here to not overstep my bounds. I think this is ridiculous. I'm just telling you. You have a deep problem going on right now. And that deep problem consists of, for whatever reason, a lack of respect for the judicial system. And it's cases like this that make me say, gosh, I can understand somebody thinking this is nonsense. I just can't. Now you're going to walk out of here in great shape, and the only thing is you had to listen to an old guy talk to you and call your case 4 times today. I just want to go on record and say I don't agree with this. I don't think it's right. And if somebody gets hurt in this, the blood's going to be on somebody else's hands. That being said, you're recommending a fine of $150 under 94-2. I think I have absolutely pretty much no authority, although I just don't believe in the logical nature of your argument, Mr. Urick, but nonetheless, I'm going to take that plea, municipal civil infraction 94-2. What is it called again?
It's misuse of streets and sidewalks, Judge.
Misuse of streets and sidewalks. Now forgive me, I got to laugh. Did she spit on the sidewalk? I don't want to talk about it. I mean, I feel like I got to go take a shower after just even presiding over this case and take a plea to the charge of misuse of streets and sidewalks. How do you plead? Responsible? So she kicked the hell out of the guy's car. He's not here. He didn't show up for restitution. Original charge is dismissed. Motion to the prosecutor. Agreement of the defense. Ma'am, go down the hall and pay your $150. And consider yourself, you should probably go buy a lottery ticket or 49 of them right now. Have a nice day.
Thank you.
Yeah, you got to the end of today?
4 o'clock.
Thank you, Your Honor.
Thank you. Anthony Stefani. Are you Mr. Stefani?
No, he's not the number on there.
Anthony Joseph Stefani, 25W701244. You have to unmute, Mr. Stefani.
Hello,
Your name, sir?
Anthony Stefani.
You scheduled a revocation hearing. I'm gonna need Beth Wiles. What is he going to do on it?
Like a brother, he guilty to each, that's
Sir, if you plead guilty here, and by the way, Amy, on that last case, make sure she cancels all the bond conditions. I have a stamp and I forgot to write it down in all the excitement. If you plead guilty, Mr. Stefani here, I want you to understand that you could have, this would be 3 prior technical violations. You could be incarcerated for 15 days. Do you understand that?
Yes.
You are presumed innocent. They have to prove you guilty by a preponderance. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, and the testifier remains silent. If you remain silent, that silence will not be held against you. Do you understand that?
Yes.
To the charge, you failed to attend your scheduled probation visit on April 21 of 25. How do you plead?
Guilty.
To the charge, failed to complete the domestic violence program with 8-week follow-up. How do you plead?
Guilty.
To the charge that you failed to pay fines and costs as ordered. How do you plead?
Guilty.
You failed to attend the domestic violence program and failed to pay your fines and costs. Sir,
Guilty.
did you fail to attend the domestic violence
Guilty.
program and fail to pay your fines and costs?
Yes.
Did you fail to attend your scheduled probation visit on April 21 of 25?
Yes.
Anybody force you to plead guilty?
No.
What's he in custody on?
Doesn't matter. Takes up at his house on the porch last Friday.
You're not going to do this, are you, Mr. Stefani? You want me to just revoke the probation? Is that what you want me to do?
No, sir. I was been in the hospital a bunch of times since I got out of jail. I did 60 days on this matter already. Since I've been out, I've been trying to get my money together and, trying to.
You didn't do 62 days on this case. You had 32 days, credit 32 at the time of the sentence, and now Judge Simpson set a bond on you because you just don't show up.
I already
Hang on.
Yes, sir.
And she set a bond on you on September the 15th, which was 2 days ago. It looks like the 15th, right? Yeah, that was only 2 days ago. So I don't know what you're talking about.
Well, you're right. He missed the last show cause here because he was hospitalized. That's what he was.
All right, let's do this. I'm going to set a sentence date. Is this the only thing he's in custody on?
Yes, Your
I'm going to is that right, sir?
Yes, sir.
Hold on, sir.
I injured.
Sir, please. Hold on.
All right. Yes, sir.
I'm going to set a sentencing date. I'm going to release you on a personal bond. You're going to show up here on when Mr. Crawford's here again. We're going from 7,500, 10% to a personal bond. So I'm reducing the bond. Amy, make sure Lisa sends that in, and you can give me the date when Mr. Crawford's here next. When are you here? October 1 at 8:30. You have to show up here, sir. You still live on Oakcrest, right?
Yes.
We'll send the notice there. Beth, I'm sorry to call you in.
Pending matters in Judge Simpson's courtroom today. I could be wrong if the docket can be checked. I thought he had okay. I didn't know it was already done with Judge Hudson.
He's done.
Okay.
Thank you, Ron.
Thank you very much. Do you have any more for me?
Theoretically, there's Shaw, but he's not on there.
We're gonna have to reschedule that again. We can give me that file, please.
I think I've got it.
Just give me the file to call.
Mr. Crawford's going to go get shot.
I can't do it. I can't do those things. I'll do them tomorrow. Give me the piece, the docket. I just need the docket. And I'll call the case off the docket. People against Jeremy Dwayne Shaw. What happened to Kenyatta Davis? Jeremy Dwayne Shaw, 24W834-431. Jeremy Shaw's not out there.
Michael Crawford representing Mr. Shaw. I have not spoken with
What happened to the Davis case?
I haven't spoken with him either. I don't know if he showed up, but I have a file. They didn't check in with me.
Wait a minute. Who was the 3 retail fraud?
Davis.
She's not here?
As far as I know, I haven't spoken with him. They haven't checked in with me either.
So Shaw was released, though, it appears. From defendant released. Okay. Jeremy Dwayne.
Judge, I checked, and Shaw is still in custody as far as I can tell at Wayne County.
Okay, this was Monroe County defendant was released. So I'll just
Now in
make
custody in Wayne County, I think.
I'll make a note, reschedule, defendant's still in custody. We're gonna have to try to get him out of there if this is, I hope this is not. I don't know, at any rate, that's it. And this is the one you also have the motion.
There's a motion, says.
I know, that's what I'm telling you. I don't want to sit here and lecture you. You send me these retail fraud, you say lack of memory, so possibility of civil litigation, you're filing a motion saying he suddenly remembered. Mr. Crawford. Retail fraud, economics, I'm not doing no contest. I mean, they have to be completely obliterated and not be able to provide a factual basis on these cases. I need those, John, real quick, please. The 3 files. Where are the 3 files?
Davis? Oh, I just handed Davis.
Where are they?
I'll just bring them. I'm sure.
Here, give me those. People against Kenyatta Davis. Kenyatta Kuru Davis. 25W8378846, 25W8380014, 25W8378845. Defendant failed to appear. She must be at Elmhurst.
Yeah, she's in custody, Your Honor. She's dealing with a pretty bad drug problem.
Did we try to rid her out? Oh,
I'm not sure.
Lisa, I'm sorry, but I'm sending all these files down, including Judge Hesson's 25W8385352, 25W83832, and 25W8374440. Find out what's going on, Amy. We're gonna have to reschedule those, or if you're sure she had proper notice and was not in custody, send them back to me and I'll put a warrant on in the next couple days. Okay? Sir, we're gonna have you released. Lisa or Amy, make sure that is done, okay? This gentleman's released on this, okay?
Okay.
Thank you.
Thank you, Russell.
Thank you, Mr. Crawford.
Good afternoon.
You too. Thanks a lot.